Good morning. This is Heather Van Wild, Raindrop Works. So yeah, the question of when we were getting ready to start, they just opened the courtroom for at least the WebEx side of it. So I double checked earlier this morning, and the judge had asked the lawyers to be here at 8:15 so that they could sort out some of the jury instruction debates that they had after the jury was released on Friday. So, you know, it's rare to see court start exactly on time, but it's 8:13, so hopefully within the next 5 minutes we'll actually go completely live. I said they just opened the courtroom on WebEx, but they have not started the video feed yet, hence why you see all this other quote-unquote junk. Let's see. Yeah, I got that set up. One of the things I don't like is I keep having to wait until the last minute to set up some of this stuff, because the streaming software won't actually let me tweak settings until the picture is actually live. Oh, yeah, Oath Keepers, Seditious Conspiracy. Ah, good. They're good. I can work on that. Yeah, I did see that there was apparently a last-minute request to try to change at least one of the defendants in that to a bench trial, and the judge said nope. Yeah, I tend to watch Scott McFarlane on Twitter at McFarlane News. He is, was it CBS? Yeah, CBS congressional correspondent, and he's been, in my view, he's been doing a bang-up job of breaking down what's been going on with all of this stuff, pretty much since, you know, the first days after the Capitol riot. At the moment, all of my stuff is ready to go. Just wait. Oh, actually, no. I need to clean up the. There we go. Yeah, I need to clean up the screen on. There's always some little tweak I have to do. Not a problem, Eric's. Um, yeah, I've been. This weekend was kind of rough. I had a lot of things break over the weekend, so things kind of went wonky for me. But things go right after this today. And then tomorrow or Wednesday, whenever the jury comes back with their verdict, we'll have the other stream for that, because it sounds like they're planning, things go right, they'll be starting deliberations probably this afternoon. I need to make sure, for some reason I'm not getting stream stats from YouTube, and I want to make sure that there's not a stream issue over there. Connection stream healthy, yeah. Yeah, that's okay. YouTube is working, so it's just everybody is watching from Twitch, which is unusual for me. That said, I mean, if people have an interest, I'm considering, in between some of these work streams, as I'm trying to get back into doing more work, maybe trying to take some breaks with doing game streaming, but it would be a different Twitch account and such. Still working on exactly how I want to do it, and the stream layout and everything. But I definitely do want to try to get back to the idea of some where's the words I'm thinking? Some more laid back. Not all gloom and doom, especially considering the next case that we're actually looking at, trying to cover. We haven't actually talked to the court yet, but I'm sure we're not going to have a problem being able to stream it, considering it's the State v. Gimbel case, which that was the incident in North Portland where the security officer shot and killed someone that was in a truck at the bottle drop up there. And that, I think, is going to be drawing a lot of media attention, so I really don't see an issue with getting access to that. That trial, last I checked, was set to run from October 19th to the 28th, so a week and a half just for the trial, plus whatever for deliberations before verdict. I kind of like the idea of maybe being able to get a little relaxation time in with some of that too, so... Why do I have a thing on that calendar at 7:30? Oh. Yeah. 3D printer broke Saturday. I broke it. I'm still figuring out how badly, and then my chair broke late Saturday night, and I don't know. I suck at small talk, so I don't want to. Yeah, I know we're gonna be starting any time, so I don't want to like turn the music back on, but I also hate leaving this much dead air while absolutely nothing is happening. Oh, that's why that wasn't showing. There we go. And I think they asked the jury to come back at 9, so I imagine that they should be starting any second now if they want to set aside like a good hour or so for sorting out the jury instruction stuff. I think there were some evidence questions too with regards to what might be shown in closing arguments. And that's the other thing I can do. Do 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 do. I don't know why I have this thing for phenomena. Sort of every time I'm like, I'm like, I don't want to wait until they're actually starting, but then I always overestimate when to turn things on. 15. I will say 15 minutes late is not what I expected. Um, that's yeah. I mean, usually, when dealing with court stuff, you're waiting on the judge. If you're not ready when the judge is ready, you're in trouble. If the judge isn't ready and you're ready, you're waiting. I used to, when I was in the military, we always used to make the joke about dealing with doctors. If you're on time, you're late. If they're late, they're on time. And you could actually, because of the way the military is, if you were late to a doctor's appointment, you could literally get in disciplinary trouble, like reprimand letters on your record, everything. So you do not mess around with that stuff. I am gonna go ahead though and I don't expect that. Oh, there we go. So, looks like, okay, so both of the lawyers for the city are here. One lawyer for the plaintiff is here. I don't see Miss Wenzel, but that doesn't necessarily mean anything. And her other attorney may be off screen or may be not in the room. But now that we can actually see them, that really helps. Oh, you took it. Okay, judge is coming in. I think. Yeah.
Yeah.
So,
And we're on the
are
record.
we missing anyone?
So
Mr.
Paul
Bastian?
and Ms. And Erin are in the hall. Do you want me to?
No. Okay, so are we on the record? So this is day 6 of Erin Wenzel versus City of Portland, 20CV 37166. All counsel and parties are present. Some of them are in the hall. And we're here to talk about jury instructions. I'm sorry that I have been here. I've been, I don't know what the right word is. I guess cogitating. It sounds better than noodling on the comparative fault to the negligent training claim. And I really don't think it's applicable.
Oh.
I mean, it would certainly be applicable in like a negligent training claim for a truck driver who caused a vehicle collision and the other vehicle driver was at fault. I've been thinking about it, trying to replace these particular intentional torts with like a less intentional, like something like conversion, like could somebody whose property was stolen be at fault in that scenario? And it seems like maybe a little bit more than in a battery or an assault scenario. But the place I come back to is, I think the legal answer, and I did some research, that there's, like the defenses to negligent training in most contexts are like immunities. They're not comparative fault typically, unless it's a car crash. But I'm not sure that the legal answer matters here, because the jury doesn't deliberate on the negligent training claim unless there's a finding on either the assault or the battery or both. And then if there's a comparative fault finding and the verdict on the negligent training claim is reduced, I think the plaintiff would, and there was an award on either the battery or the assault or both, and it was higher because it hadn't been reduced by the fault, I think the plaintiff gets the higher number. Does anybody think that's wrong?
Go ahead. And then Matt, then I'll speak.
Yeah, I think we had prepared that Mr. Manlove would be addressing this, but I'm jumping up quickly, so I apologize. I just wanted to briefly draw the court's attention to defendant's proposed verdict form, because with the concept of no duplicative damages, we did envision that the jury would enter damages for the assault, damages for the battery, and then damages for the negligence.
Yeah, that table thing is a little weird.
Okay, and yes,
but I understand where you're going with it.
It's an attempt. So yeah, the comparative would only reduce damages for negligence.
So I guess I'm just wondering if there's a deal we can broker, which is I don't think it matters in terms of the verdict. And so in that sense, I'm not sure it actually hurts the plaintiff if I instruct on this, and then the bases are covered in the event that I am wrong, in that it does apply even when the predicate tort is an intentional tort. So Mr. Burgess, I'm just checking in with you to see if you have a thought, or you can give me an answer about that.
Well, I mean, it would depend on what, I guess, the instruction is. I mean, based on what you just said, my assumption is that it would be something like, you can't compare fault with respect to the intentional torts. And then you have something in the verdict form that just says, like, if you've, answered questions, whatever they are, 6 and 9 above in favor of the plaintiff, then proceed to question 10, and then that would be the failure to train claim. And then under that, it would then somehow incorporate the comparative fault there. But I mean, I assume that's what we're talking about. But I agree with your assessment in general, which is that I think it wouldn't make a difference, because if plaintiff got her prayer on the battery claim, for example, then it's like, then any comparative fault assessment of the negligence side of things would be irrelevant, because it wouldn't change the outcome of the verdict. My concern is that it could be very confusing to the jury, that they might, by having it in the instructions and by having it somehow incorporated into the verdict form, that they may be confused about whether or not her alleged fault or negligence, how that plays into the intentional tort claims. And I have some concern about we're talking about, like, underlying predicate torts and stuff, and I have significant concerns about the jury being able to suss that out and being like, okay, well,
juries do this all the time.
Okay, I mean, I get that, but I guess my baseline position is, is that it seems like defendant wants it both ways. It's like, either I can't have the negligence claim without a finding of one of two intentional torts, in which case comparative fault doesn't make sense and is inapplicable, or I have a separate claim, in which case comparative fault might arguably be applicable. But having it both ways is unfair to the plaintiff, because in that context, they both get the, like, you can't have your negligence claim without also finding these intentional torts, and we get to argue that nevertheless, with respect to the conduct that's intentional, that your client was comparatively at fault. seems inappropriate given the case law about, which goes back to like the 50s, which is that intentional torts do not involve either comparative, at the time it was comparative negligence, now it's comparative fault. This precise scenario hasn't arisen, but I think the cases I cited to in my brief would, I think, seem likely that the Court of Appeals would agree with your initial assessment that you indicated on Friday and what I thought about it as well, which is that if this is basically a negligent causing of an intentional tort, then you shouldn't compare the fault of the parties. So that would be my position to start out with. I don't know what the instruction would look like, but I don't know if I'm in agreement exactly with that at this point.
I don't disagree with anything you say. The trouble is, there's not a super clear-cut answer here, and I'm not 100% certain that the city is wrong. And if there's a way to give the instructions and take that error out of the case give the instructions carefully so that they get their instructions, I think in light of the fact that there's no real potential harm in the verdict to the plaintiff, because I think she would get the higher number, then that's what a judge is gonna do.
Right. I guess what I'm wondering is like, I would be confused if I were a juror to know what fault I'm comparing with. Like, are we comparing the negligent failure to train with her being in the street? Are those the things that are being compared? Or because it seems like there's no way around it that that their jury is going to be asked during deliberation to compare being intentionally assaulted by someone with her own negligence. That seems like that's the problem that I have fundamentally with them going back there and being asked to deliberate on that topic.
Your Honor, may I speak?
Yes.
Yeah, so I think with respect to Mr. Burgess's last point, you said initially that, you have, whatever instruction would make clear that you can't use the comparative fault with the intentional tort. That seems to be real clear. The other thing is, we do have this issue of the duplicative damages, and you just said, if they get one number on the assault and battery, and then a different number on the negligence, that our verdict form was such that if they don't find for the assault and battery, then they don't have a negligence claim. If she was never assaulted, she's never battered.
Yes, and I agree that's the appropriate progression.
And then, I think the verdict form is a roadmap, and then an appropriate roadmap that we drafted. What was I going to say? One of the problems in this case, if I may, is that in paragraph 11 of their complaint, their allegation of negligent training was extremely vague, and we sort of just in the last few days have gotten sort of more clarity about what really the training is. And I think this case has been tried on this idea that, as the court has said, there was an issue about using batons, pushing people from behind, during the dispersal. If that's the sort of framework of the plaintiff's negligent training claim, and you've ruled that there's some evidence that the city had notice of this, and that's why this claim, we lost that our motion for directed verdict on that claim, and it's going to go to the jury. And what I'm saying in the brief that I submitted is that because her behavior and her comparative fault, failing to disperse immediately, failing to obey the lawful orders of uniformed police officers, there's a sufficient factual nexus between our comparative fault specification and the plaintiff's specification of negligence as it's been presented in this trial. So because of that, because there is sufficient factual nexus, there's a connection there, we believe that the comparative fault instruction is appropriate.
Okay. So I am going to give the comparative fault instructions, and plaintiff is obviously free to make exceptions to them, and should. Uh, But there can't be any argument comparing, and this is kind of I don't even know how you do this, but you can't say she's comparatively at fault for getting hurt because of the acts of the officers. You have to somehow make a really awkward argument that the jury compares the negligence of the city and its lack of training regarding pushing with batons or hands to her negligence in failing to get herself out of that environment.
The case was tried with the pushing of the batons,
Should there,
not the hands. You just said the hands, it's the batons, and that's sort of how we.
I guess the claims are for the baton strikes. As I understood, there were pushes, but the tort claims are for being pushed in the back with a baton and then being
Right.
hit in the leg with a baton
Correct.
in the fourth encounter.
Although I would say that Lieutenant Sheening's testimony was, and the testimony of other officers, was that some people had batons and some people didn't, and some people were shoved without a baton, some people
Right,
had a
but
baton.
those potential torts aren't what the jury is deciding.
No, I understand that, but what I'm saying is that I think narrowly tailoring the notion of training as though there was some sort of like, as though it was like completely different.
You can talk about
Right.
training on pushing, like
Right.
that's fine with me, but just in
Right.
terms of what the city can argue for comparative fault, I just don't want to hear that she's responsible for getting hit because she's there. So you've got to make the argument training versus remaining in the area, and I know that is kind of it just requires some logical gymnastics to kind of omit the baton strikes.
I preferred awkward over logical gymnastics.
Okay,
but
all right,
I'll-
awkward is good. Logical awkwardness.
Can I make one
Yeah.
point? And so two things that this raises for me. One is I think the comparative fault instruction then needs to have a sentence in it that clearly says you are not comparing
Yes,
something along those lines. So it's clear to the jury
yes.
they're not like
we'll
they're
put the
not like.
sentence somewhere.
Okay.
I promise, or in
And-
more than one place.
And then the other thing is, and this came up the last time I tried a case in Multnomah County, and I asked, now I'm blanking on his name, a different judge about whether or not objections or exceptions to jury instructions needed to be done can just be done beforehand so that I'm not standing up and looking like a jerk and objecting to your instructions while they're being read, which, as I understood it, used to be the rule that you had to do so or you waived it.
So it's whatever the Court of Appeals says, right? I'm not going to give you advice about how to preserve your exceptions because I'm not entirely sure. And so you can tell me now what's a problem, and then I think the rule is you make them at the first available opportunity, and so people will do it like after closings, and that's never. I'm unaware of that being an issue.
Okay,
No.
When I did it, then he looked at us like we were,
Yeah, it shouldn't feel
doing
like
something.
it should not feel like you're gambling, but it
Right.
may.
And as long as, yeah, I just. Do you have any thoughts on that, Bill?
Sorry, I was thinking about something else.
No. Do you have any objection to me putting my objections to particular jury instructions
On the record?
on the record after
Well,
after they're read or something, so I don't have to interrupt the jury instructions? Is that something that you would stipulate to, so that?
I think either before or after, but also that raises a point, Your Honor. I also want to put something on the record to preserve our record, an objection to one of your rulings. So
Okay.
I'm not sure if.
All right, and then we really need to plow through these jury instructions. And also, we are missing juror one. I don't know if you heard that. I've excused juror one, who is an alternate, whose husband called and said she's had to go to the hospital because of a back injury over the weekend.
Okay.
Which,
Oh.
you know,
That was the alternate.
she's an alternate,
Okay.
yeah.
Do you want me to make my argument?
Yes.
Yeah. Well, so, Your Honor, I think,
But you're just preserving it for the record, so shorten it up.
yeah, so we were gonna offer, a, amended version of, the incident commander's summary, which is, 107, exhibit 107, and I think our version was going to be exhibit D, is that correct? 107D. And so this contains many of the redactions that the court requested. However, this version contains references to the crowd going down to the Portland Police Association, or also going to the North Precinct. The basis of the objection is that, you know, there's evidence in the case that this is where the crowd was going to go. I think it's, you know, it was unfair to restrict Commander Dobson's testimony in such a way that he could not explain his concerns that evening. In fact, there was a juror question about, hey, did you receive any complaints from the community or calls or something to that effect prior to calling the unlawful assembly? And certainly at least his belief that they were going to go there that night and create acts of you know, criminal vandalism or property destruction is something that should have been allowed on the record.
Okay, so I want to go back through the jury instructions, and I am going to start toward the beginning again and just stop on pages that I think we need to come back to. So now I'm back on evidence received for a limited purpose, which is page 6 of the draft instructions. And my last recollection was that I decided there really wasn't evidence received for a limited purpose, and so I just wanted to make sure nobody's come up with any.
Yes, Your Honor, I think the videos that were played of other officers, other incidents, I think those are received only for the limited purpose of the negligent training claim, and they are not relevant to plaintiff's assault.
I guess I need to know which videos.
Yeah, I agree. Mr. Burgess offered a video with Mr. Taylor in it, Officer Taylor, and then another video towards the end of his case from 2 different views. So basically,
10, 11,
they're
12.
11 and 12. 11 and 12.
The first one you mentioned was 10, and then the second 2 are 11 and 12. Sorry,
Okay,
just
no,
wanted
thank
to,
you.
so everyone's following along.
Officer Taylor was in Exhibit 10, and then an unknown officer in Exhibit 11 and 12. And I guess the only concern, I mean, hopefully the jury's been paying attention and they don't think that that's plaintiff in those videos, but those videos are not offered to prove the assault and the battery. They're offered as relevant only for this contextual negligent training claim.
I guess you didn't object to them on that, object to their admission for. I mean, I allowed the pictures of what happened on the videos of what happened on the bridge because Detective Kammerer just kind of, I think it was Kammerer, he was just he was opening a lot of doors. And that's why I allowed those.
Yeah, I think in limine, the city moved to exclude all of the videos that plaintiff sought to introduce because none of them involved plaintiff. And the city's position was that those videos were all prejudicial because they tended to show, you know, other incidents, with the implication being that plaintiff was treated in the same way. And I thought the court granted that motion. And then these videos were allowed for the purposes of the negligent training.
Okay, that I think is fair. And so not the ones on the bridge, but the one with helmet 12, that's the one you're talking about, right?
I'm talking about both of them actually, because I think the ones on the bridge were offered later in plaintiff's case after he argued that Detective Kammerer opened the door to sort of a wider you know, body of evidence.
Okay, I don't really think this matters, but I think it's a reasonable request, so you just need to, we just need to have the video numbers, the exhibit numbers again.
10, 11, and 12.
10, 11, and 12, and so I guess it would, Anna, are you, can I dictate?
Yes, you can dictate.
Okay,
Your Honor, can I just put something in, just be heard for a moment
Yes.
on that issue? So when we discussed this instruction on Friday, my understanding was that the court did not think that impeachment, for example, was received for a limited purpose. And so, because the number of defendants' exhibits were offered as impeachment, and so, and one of the reasons, in addition to the reason just explained by counsel, that Kammerer's comments opened the door to conversations about what happened somewhat more generally on that day, was that he had made statements to the effect that 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 was not their practice, or that isn't what they were doing that night, which then prompted me to show videos to contradict that.
okay, was that 11 and 12?
That was 11 and 12. That is how those came in. So I think I can kind of see the argument for 10.
Okay,
although
then I'll limit it to 10 because that seems fair, and that is why I let in the bridge 11 and 12, because I thought he opened the door with his testimony of this just wasn't happening. Now I'm typing it to you. Okay, here's what I got. The court received evidence of video 10 or exhibit 10, maybe comma, a video for a limited purpose. You may consider it only for the purpose of plaintiff's negligent training claim, not as evidence that may be considered for proving plaintiff's assault or battery claim. All right, and then did you send the stipulations of fact for the stipulations of fact? There's something about the medical bills and,
Your Honor.
yes.
Yes, we prepared a document called stipulations of fact, and I think my assistant
Okay, and-
just emailed it.
And Mr. Burgess is okay with them?
So
go ahead, Bill.
I think he was with the 18 or so that I proposed.
Okay.
He wanted to add another one, and I didn't add that. This was basically a stipulation that neither the city nor Ms. Wenzel are aware of any witnesses to and this is where we get into the police use of force.
You could say
Assault.
uses of force, or I think like the police uses. I think assault's out, so I think I think we already litigated that question.
I tried to, any admission that they made that was contentious, I took that out. So you want to add a stipulation that.
What is the fact?
So I
Which one?
submitted an RFA that just said admit the city doesn't have any witnesses to the assaults on Ms. Wenzel, which they admitted. So I know that the assault, it should be articulated differently based on your
So
prior
what
ruling.
we were talking about is neither the city nor Ms. Wenzel are aware of any witnesses to the police use of force against Ms. Wenzel.
Okay. Can,
So that would be stipulation, that would need to be added to this document that I sent to you just a moment ago. Stipulation 19.
okay.
I haven't received that document.
And John is
Okay.
the stipulation about Baskerville. Did you?
I emailed that out just this morning at some point.
Okay, so
After you sent me your email.
what do you want to do? Because I think the court needs something on that.
I think did you?
I have the one on Baskerville, and then I also have the one on Officer Lehman that was read to the jury currently in the stipulations of fact.
Okay.
Is that also included in your copy, the one that you're sending?
No, it was not. So these would be either needed to be blended into our stipulations of fact document or read kind of separately. The Lehman one we're fine with because we all agreed to that. I think it's the Baskerville one. I wasn't quite sure how that was going to end up reading.
That's the one on your. I printed it out.
Okay. Here it is. Do you all agree on the Baskerville stipulation?
No, Your Honor. We haven't yet discussed it. The city's position is that it should be tailored down to simply the fact that the videos he reviewed did not have Miss Wenzel in them. I don't think that his substantive testimony needs to be reiterated or emphasized.
So what do you want it to say?
Dr. Baskerville mistakenly stated he thought he was given a video that showed plaintiff. None of the videos provided to Mr. Baskerville contained plaintiff in them.
Okay, I think that works. Can you?
Your Honor, can I just be heard on that?
Yeah,
Very
yeah.
briefly.
you
The
change
reason
the
I
time?
included the sort of the contextual details is because defendant could have but did not cross-examine Dr. Baskerville on this topic, and so it didn't come up in my redirect. I think it's fair to point, left alone as a bare statement, it has sheds a kind of negative light on Dr. Baskerville's testimony that my stipulation, which gives accurate context to the statement, is appropriate so the jury knows why they're being read it. And whereas just the bare statement is sort of seems like the court, stepping in, regarding his testimony in a way that ordinarily would be accomplished during cross, and then I would have been able to rehabilitate him on redirect and say, that isn't the video, but is that video the kind of video that is that?
So Mr. Burgess, I'm going to give the city's version. I'm not going to give your version.
Right.
You need to create your record, but I just want to explain, it is going to take me, I don't know, maybe 30 or 35 minutes to read these instructions. That is just a gut estimate. It's going to be, these are long instructions. If we go into tomorrow, we may be in trouble with jurors. So we need to keep moving. So now I'm on the burden of proof instruction. And if I cut you off in the interest of saving time, when the jury is out of the courtroom, just make a note that you want to keep supplementing your record. And we have all the time in the world once the jury is out of the courtroom to do that. So now I'm on page 14. On the burden of proof, I guess I think I already said I'm not giving the requested sentences on either side. Just the standard, yeah.
So the third sentence is a standard sentence, it's just one. I guess it's in the standard ones. One just says affirmative defense, and one says.
But does the city have any affirmative defenses
Well,
that are
comparative
still in
fault,
play?
if it's being given, would be an affirmative defense.
Okay. All right, then we can give that third sentence. I know we had this exact conversation on Friday. I'm sorry.
No, I don't think we talked about it.
And then And then I'm moving on to common law negligence. Mr. Burgess, did you send the specific allegation of negligence that we should put in here?
I sent an email on Sunday morning, I want to say, or just before
Do you have
noon.
it? Does the city have any issue with,
I think, yes, we
it should
did.
just say negligent training. It shouldn't be complicated.
Yeah, it is actually it is complicated. He's got, for example, he reiterates causation like 4 times or 2 times at least.
Oh, okay.
I'm fine with it being pared down. I just was using basically the negligent training from the 1983 claim, but you adapted to negligence.
No, it just needs to, there's just usually a specific sentence. So the plaintiff has made a claim for negligence against the defendant. And then it could just say, comma, specifically the plaintiff alleges that defendant
Failed to train
negligent in its training of Portland police officers.
with respect to pushing people with batons during a dispersal.
Yes.
So I think that's the.
Okay.
That's fine
That
with me.
captures it,
That's-
okay.
Yep, no objection to that.
Defendant was negligent in its training of Portland police officers with respect to.
Pushing people with batons in a dispersal situation.
During a lawful dispersal.
Maybe we'll leave off lawful dispersal.
Dispersal situation.
During a dispersal of a crowd.
Is this taking the place of common law negligence, page 18 of your proposed?
Yeah, it's just like a sentence that's being dropped in there. That's
Okay.
typically how that instruction is given.
Okay, yeah, that's
Okay.
that's fine.
Okay. Okay, so now I told Anna to take these out, but I will, can you put comparative negligence back in?
Both instructions. I have 21.01 and 21.02.
Yes.
And then 21.06.
Oh, yeah, 21.06, the conduct of non-parties. I guess I'm wondering why the defendant wants that. The only thing I can think of is like the protester who accidentally bumps into Mrs. Wenzel and bumps her into the cop, who then hits her with the baton in the leg. I don't know why, or do you really want that instruction and why?
I don't think we need that instruction,
Okay.
particularly if we're gonna be going with but for causation. I think it was that other protester's
We're going with
actions.
substantial factor, and I'll talk about that in a little bit, but if we go with substantial factor, you want this conduct of non-parties instruction?
I think that would be appropriate.
Okay. Okay,
But I mean, this one is conduct of non-parties, comparative fault not at issue. The comparative fault instruction is being given, then presumably this isn't the correct instruction.
look at this again.
Mr. Burgess is correct. I think this speaks to conduct of others.
Okay, so we'll pull 21.06 out. And I am gonna give substantial factor instead of but for causation. The city talked about it being only applicable when there are multiple tortfeasors at issue, but the Court of Appeals has said no, it's multiple causes. And I think, as I understood Dr. Best's testimony, it's like a bunch of factors, and in this case, they're all at the same time or they're very close in time, combining to create the PTSD response in Mrs. Wenzel, so I am gonna give substantial factor. And so I think it's the cases Haas versus the state of Carter that I am relying on.
I have 2 questions.
Yeah.
So that, the uniform instruction, you can either write harm or injury for it.
I'm just gonna say harm.
Okay.
Harm
And
makes
then
sense, given what you just said, harm makes sense.
there is a final optional sentence. A substantial factor is an important factor, but not one that is insignificant.
Yes, yeah. Okay, and so,
And that's in lieu of but for, so they'll only be getting a single
Right.
instruction.
yeah. All right, so now I'm on battery, and let me tell you what I'm gonna do here. Everybody's in agreement on what a battery is, but obviously there needs to be a reasonable versus unreasonable force assessment in determining whether or not the jury gets to battery. And so I think that we'll go with the plaintiff's version, except at the beginning, so it should say the plaintiff claims that the defendant committed a battery. And then from the defendant's version, the next sentence will read this sentence. A Portland police officer is justified to use reasonable force to accomplish an official purpose, such as dispersing an unlawful assembly. To find that this requires plaintiff to prove that, and then the first element will say that it'll be 2 from down here. Yes. So that they'll first have to find that one or more Portland police officers used unreasonable force in order to arrest plaintiff or in order to disperse plaintiff.
Yeah, that was a mistake.
And then it will say, and then it will,
Well,
so I'm just telling you what I'm going to do here, and then you can
okay.
tell me if you think it's wrong and why. And then go into, and then it will be just the standard elements. The defendant acted intending to cause harmful or offensive contact with the plaintiff, and the defendant's actions directly or indirectly caused a harmful or offensive contact with the plaintiff. Except maybe it should say the defendant's officers acted, or the
I think that makes sense.
Yeah, so I've kind of just given you some sausage.
And then do you want to say the defendant's officer's actions?
Yes, yeah.
Or the defendant officers acted and the defendant officers' actions, okay.
Yeah. And then I'm gonna ask Anna to read it
Okay.
from the start to see if it makes sense.
The plaintiff claims that the defendant committed a battery. A Portland Police Bureau officer is justified to use reasonable force to accomplish an official purpose, such as dispersing an unlawful assembly. This requires the plaintiff to prove that 1, that one or more Portland Police Bureau officers used unreasonable force in order to disperse plaintiff. 2, the defendant's officers acted intending to cause harmful or offensive contact with the plaintiff. And 3, the defendant's officers' actions directly or indirectly caused harmful or offensive contact with the plaintiff.
Okay, I think that's right. My only question is, should it all say PPB or should it all say defendant's officers? I think it's probably awkward to change the terminology partway through.
I don't have a strong preference on that. Which terminology is used. Plaintiff's position is that saying in order to disperse plaintiff concedes an awful lot to the city, because first of all, there's zero evidence from an officer saying that the reason he battered Ms. Wenzel was in order to disperse her.
So that's a weight of the evidence argument, in my opinion, and that's what you're arguing to the jury.
Right, but then I won't be able to tell the jury that she wasn't being dispersed when she was being hit from behind, because the court just told them that she was.
So do you want it to say, you want such as dispersing an unlawful assembly taken out?
Yeah, I don't think it should say such as dispersing an unlawful assembly. It should just, and the number 2 should just say that one or more Portland Police Bureau officers or defendant's officers used unreasonable force, semicolon, and then the next one is just like it. We don't know the intention, behind the officer, so it seems inappropriate to
Well, it's
supply
just a
that
statement
intention.
of the law. It's not it's not a comment on the evidence.
Right, right. And I think the second sentence should read, Portland police officers, just as it's written, to accomplish an official purpose, and that, such as dispersing unlawful assembly, that is an example of an official purpose. And then, just like the court said, he can argue that, one, she was dispersing, or whatever he wants to argue.
Right, but now one of the elements of the claim of battery is that I proved that they used unreasonable force in order to disperse her, but I
Okay,
have
just
no
maybe,
intention.
how about it's just used unreasonable force against plaintiff?
No, I think it's important that the reasonable force a police officer can use reasonable force to accomplish an official purpose.
Yeah, so
But-
that's in there. That statement of the law is in there, but in terms of the element, I think Mr. Burgess has convinced me. It can just say used unreasonable force against plaintiff.
Which sentence is this now?
It would have to be the first element.
Right,
They
number
have to
one.
find the unreasonable force before they move on to the battery. Yes,
I'm gonna change it all to Portland Police Bureau officers.
sure, or just, or you could just maybe go to just police officers, but yeah, okay. So, and I am moving on to intent. I'm just gonna give the standard instruction for intent. These cases cited by the city, they still don't change the elements of, they still don't change the definition of intent, and they're a sort of a further instruction on what battery is, so they go beyond just what intent is. So I'm not gonna give those instructions.
Are you okay with the jury instructions when you select his or her? If I just do his, like literally his or her? Because we don't know.
I would say there,
Okay.
we actually just have no idea who the officer was.
We don't know their preferred pronoun, so,
We do not.
right.
Okay, and then now I'm on the damages preliminary instruction. I think we were just going with the plaintiffs. They were basically the same. It just one uses fault and one uses negligence. So we were going with the definition that uses fault. And then on non-economic damages, we're gonna go with the plaintiff's version, except we're importing the sentence from the defendant's requested version that says the amount of non-economic damages may not exceed. You can either put that on the verdict form or in the instructions, obviously, and I preferred in the instructions.
Your Honor, may I be heard on this?
Sure.
So number one, plaintiff's requested version, sub one there. This last part of that sentence, mental suffering, emotional distress, etc. Plaintiff has sustained from the time she was injured until the present.
Oh, right, in the future.
I think we should stop it there. One, because there hasn't been any evidence that she will sustain future emotional distress.
Well,
I
so
don't think that's-
previously you were taking the position that future emotional distress is not a category of damages that can be awarded under the law. Have you backed off of that and now you're just saying no evidence?
Good.
Well, I think it depends on the evidence. If there's, future wage loss, if there's some evidence of permanence or future medical treatment, then that would be appropriate. But in this case, all of the compensatory damages are retroactive.
So these are non-economic damages, not economic damages, and Ms. Wenzel's testimony was that she suffered and continues to suffer from pain, mental anguish, emotional distress, and humiliation. It doesn't have to be PTSD, although I think it seems like a fair inference from the testimony of Dr. Best that Ms. Wenzel did not instantaneously stop having PTSD as of the first day of trial, so that seems like a silly position to take. And I think her own testimony is sufficient for non-economic damages, which have no fixed measure, and this is the standard jury instruction. So
Yes, I think I will instruct on future. I think there's enough to reasonably conclude that it's an ongoing situation. And then I'm on the damages economic. And so we'll give the plaintiff's instruction with 1 and 2, and then we'll import the total amount of economic damages may not exceed the sum of from the defendant's version. What's the number?
just a second, I think it's
Oh, I don't think there are future, are you,
15.
There are no future. So these are contained in our stipulations, 16, 17, and 18.
It's $15,605, and let's just get rid of the 80 cents or whatever. I think that's
15,605.
May I check the math here?
yeah. Please feel free to check my math.
I have $15,606.
$606 is fine.
Did I just give her more money?
if you've
One more dollar.
So if you've stipulated to the total, that's just everything that's been accrued up to this date, so it's not future. If you've
Right.
already stipulated, okay, so we'll take that out. Okay, I am not giving plaintiffs requested special instruction 1. I am going to give the state, what's on the defendant, I'm gonna give the state statute definition.
You mean from like 161 or?
Oh, there used to be a statute. I don't know if that statute is still in effect.
So in plaintiff's response to their proposed instructions, I pointed out that the passive resistance definitions and the definitions they were providing are from criminal statutes, and I don't think those should be applicable here. What constitutes passive resistance is constrained by the Constitution and not by this. I mean, usually resistance as an instruction from that statute is given in regards, in response to where there's a self-defense to a use of force, and there are instructions relating to resistance that stem from the criminal statutes, and they're not really applicable here because they're, constitutional constraints on what constitutes passive resistance, and I think that it would be inappropriate to give them an instruction that would, in essence, be saying they can use force that's unconstitutional under the Fourth Amendment, but is reasonable under Oregon law. That seems like a problem to me.
Manlove.
So, Your Honor, the briefing that I submitted, I think is appropriate. State v. McNally, the statute at issue there was interfering with a peace officer. Both components, where a person physically does something to interfere with the officer's attempt to do something to the third party, and also the failure to obey a lawful order. And to some degree, both of those components are involved in this case from the city's perspective. But the State v. McNally, did a very thorough discussion and evaluating the Court of Appeals decision, and it defined passive resistance very clearly as non-cooperation conduct that does not involve violence or other active conduct. And then the State v. Bledsoe case further elaborated on what active conduct is. The fact that those in the criminal context, that's beside the point.
I'm not concerned about that. The Constitution is the Constitution, regardless of the vehicle.
His argument about the Fourth Amendment, mean, the Fourth Amendment is always a balancing of the intrusion on the individual's liberty interests versus the governmental interests, and it's that balancing. And police officers can use force on passive resistors, the classic sitting in the intersection. That force has to be reasonable and appropriate. And that's exactly, gets to our other instruction on reasonable force, which is that force which is necessary, only necessary to accomplish that official purpose. So,
Okay, so here's what I'm gonna do. I'm gonna give the passive resistance is non-cooperation with a lawful order of a police officer that does not involve violence or active conduct. And then I'm just gonna use the active conduct is the obstruction of the work of the government or police officers through active physical conduct. And I'm not gonna give the walking away.
Those are the two separate instructions or the same instruction?
Put them in one.
these came in as two separate instructions, defendant special requested jury instruction number 16, and then that's passive resistance, and then special requested jury instruction number 17 is active conduct. We sent those to the court.
Okay, and I'm not going to give plaintiff's requested special instruction 2 on justification privileged use of force. This is a use of force instruction from a 1983 claim, isn't it, Mr. Burgess?
I'm sorry, I'm flipping back, I'm not quite there yet. Yeah, I mean, it's not identical, it is
Okay,
modified.
I'm not gonna give it. Okay, I need to talk to the city about the interfering with the peace officer misdemeanor elements and the disorderly conduct in the second degree misdemeanor elements. I have concerns about those instructions, and I need you to tell me this. We talked about it on Friday, but I need this specific basis you think. I need to know what the facts are that require me to give these instructions.
Well, Lieutenant Shanning explained that there needs to be the authority to act.
Why don't you want, you mean in terms of declaring an unlawful assembly?
Correct.
Why don't you want the arson instruction instead? Why do you want the, so here's my concern. My concern
Well,
is.
there's no evidence, I mean, there's no evidence that she was burning stuff. But there is evidence that she didn't disperse immediately, which would cover interfering, and then also that she was in the roadway blocking traffic. I guess that was.
So that's what I'm worried about. I mean, the only witness we have to what happened to Mrs. Wenzel is Mrs. Wenzel. And I feel like there's been no testimony from officers that they took the action they did because they thought she was engaging in one of these two misdemeanors. There's just no evidence in the record of that. And
with respect to Ms. Wenzel, but definitely with respect to the crowd. I mean, the video shows.
Right, but that's not a claim that the jury, I'm not going to give interfering with the peace officer and disorderly conduct.
Your Honor, may I be heard on this?
Sure.
We saw video evidence of Miss Wenzel directly behind the shield wall, and we saw photograph stills in which she identified herself behind the shield wall right at the moment that the police officers were pushing against it. And we saw her in close proximity, what appeared to be a push from a police officer. So to the extent the jury believes that that was the push involved in this case, at that moment, plaintiff would be involved in interfering with a police officer and disorderly conduct.
I'm not going to give those instructions. I am going to give authority to direct traffic on a public right-of-way. I am going to give the city code on pedestrians. I am going to give the instruction on authority to disperse. I am not going to give the civil commotion immunity instruction. I am not going to give the civil commotion defined instruction. I am going to give the justifications requested special instruction.
Your Honor, can I just?
Oh, I might have taken that out of order, yeah.
No, yeah, there was one, the apparent authority, but as I understood.
Oh, I think I made an error in allowing myself to have an unstapled set of instructions. And I think I may have just gotten that out of order, so I will look for that. Oh yeah, I go from 44 to, I think I pulled it out and I was like, just didn't know what is this. So let me see if I can find 45, page 45. Okay, yeah. Yes, it has a sticky note with a question mark on it.
So
There's no, so as I understand this, there's no allegation that they're acting under a law that's not constitutional, is there? I mean, isn't that what this instruction is for? It's kind of a qualified immunity type instruction.
Not qualified immunity, but it is very nuanced, and the city has this in there, or had it in there based on, depending on what plaintiff's presentation would be. It is an affirmative defense along with riot immunity, so to the extent the court's not allowing that immunity, I think this one would be off the table as
Okay,
well.
so apparent authority immunity is out, thank you. And then, okay, so the justification instruction and the reasonable force instruction are, how are they not duplicative?
well, and Your Honor, I just wanted, I think in my response to their jury instructions, I pointed out, so reasonably believes it is, I mean, my reading of Giggler, I'm not sure how to,
Yeah,
the city of Klamath Falls is that it said, force, that no more force than is necessary, which is, they have switched around in their instruction to make it significantly less strong of an assertion that the officer reasonably believes is, well, it says it necessary, but I assume it means it should be believes is necessary. But that's not what that's not what that case says. The case says that they can't use any more no more force than is necessary is qualitatively different than what they have in their instruction.
you mean, so are you talking about the justification instruction or the reasonable force instruction?
Well, so I mean, the problem is they're kind of the same instruction, but they're half is in one and half is in the other. But that sentence just left off is just not true. It is just not true that a peace officer.
Okay, tell me why it's not true.
So it says a peace officer is justified in using physical force when he reasonably believes it necessary to accomplish an official
Which
purpose.
instruction are you looking at? The justification?
The justification one. It's not just based on purely on a subjective intent of
That's
whoever.
true. Okay, so we'll give the reasonable force. So the justification instruction is out. The reasonable force instruction is in, and they need to be they need to be combined. So maybe it just says in the reasonable force instruction, showing a reasonable force is a complete defense to a claim of assault or battery. And then the reasonable force instruction needs to be amended slightly so that it says cannot be held liable for assault or battery. It doesn't just, so it's two claims.
Is there a reason that can't go under justification as because I think the justification instruction is correct. It's just plaintiff wants to add more to it. Is that correct?
No, what he's saying is it's not just a reasonable belief that it's missing only the amount that's reasonably necessary qualification.
Well, Your Honor, may I make a proposal? So what if we say for justification, peace officers justified in using physical force when necessary to accomplish an official purpose, such as dispersing unlawful assembly. So we take out the reasonably believe. I mean, I think counsel is correct that it injects, the subjective kind of element,
Well, I mean,
or when reasonably necessary to accomplish an official purpose.
my problem is the only way to make it accurate makes it identical to the following instruction.
Yeah, there needs to be just one.
And the justification language comes from ORS 161235, and so
Right. Yeah, but the jury doesn't care about that. They don't know what that word means. And so we can also just change it to be something that makes sense to regular people.
So we're going to go with our reasonable force instruction.
And then just,
A claim for assault and battery. Then the out of sense, reasonable force is a complete defense to a claim for assault and battery.
yeah, I guess a finding, if you find that the police officers in question used reasonable force, that is a complete defense to a claim of assault or battery.
Your Honor, sorry to complicate it, but one more thing. In defendant's proposed verdict form, there is a line that says, something along the lines, after was there an assault, the second or third question is, were the officers justified in using force? And I think that whatever instruction we use should be mirrored in the verdict form. So I just want to make sure that what we're doing with this instruction is going to be workable.
I don't even know that you need that line in the verdict form, because they shouldn't be finding yes unless they have already decided that they weren't justified in using force. But if that line is in the verdict form, it almost seems like it should be above the finding, because
That's fine
you
too.
can't find assault if it's justified. And so the instruction should be, if it's justified, you skip the question, or because you can't, if you find that it's justified, you can't then find assault.
And if we're
Right.
going to use justified in the verdict form, could we title this jury instruction justification?
It would be smarter to change the language in the verdict form, just to use words that people understand. But
And I think, I think it might be confusing. And I mean, my position is that the more straightforward verdict form that we proposed.
you need to pause. Can you go see if the jurors are here?
We have 11.
Oh, was somebody checking?
I had Audra check.
Oh,
Check
thank
to see
you.
if everybody else is there.
Yeah, thank you. And then, Mr. Burgess, do you have a rebuttal?
I have
case?
one witness, 10 minutes tops.
Okay, and what's the subject of the rebuttal? What evidence is being rebutted by your witness?
Well, so both Mr. Lieutenant Shaning and, as I understood, Plantiff and others were taken both during both cases. But so I'm calling Jacob Prescott, who was also present on the day in question. He's a journalist, and he can authenticate one of the videos that I had intended to show, which is Exhibit 2, and he was present for a large group of officers during a dispersal on that evening, and can give testimony about that. I can't imagine.
So, okay, I heard what you said, but I still don't understand. He's giving testimony about August 14th?
Yes.
But like, whose testimony in the city's case is he rebutting?
Well, I think Lieutenant Shaning's testimony was that the force used on that evening was reasonable, or that it was based upon the. Yes.
Lieutenant Shaning didn't testify in our case.
Yes, you listed him as a witness, and you took him out of order. That's the point. And you also, I didn't object because my understanding was that you were taking Ms. Wenzel's testimony also out of order. I didn't know you were going to call her again because we discussed taking witnesses, including the experts, and both Dr. Best and Dr. Yang, and you proposed Ms. Wenzel, and you proposed Lieutenant Chaining, and the questions that were asked during Ms. Wenzel's testimony went far beyond the scope of the direct. And so my presumption was that you were also taking her testimony out of order as you had requested prior to trial. And so I think that to limit it solely to the 3 witnesses that they called of the 17 that they listed, or 20 in their witness list, would be unfair, since it
I
gave...
think that that is what it has to be, because even if they were sharing witnesses in your case, you decided when you rested, right? And so if there was affirmative testimony you wanted to put on, you could have put it on in your case.
Well, I couldn't actually, because I didn't know Mr. Prescott.
That's different.
Right, that's what I'm bringing it up now. My point
Okay.
is that it's extraordinary. It was extraordinarily difficult during this case to find witnesses who were willing to come forward. The publicity of this case has somewhat made that
Okay.
easier. Mr. Prescott, I did not know his name, and I did not communicate with him until Sunday of this week, and I did not know. I knew the video that we offered as Exhibit 2 was offered his pseudonym on Twitter. It's not his actual name. I had no way of identifying him prior to his information being acquired. So I would like to offer his testimony. It will take no more than 15 minutes tops, and I don't think that although I understand that it is a little broad from the 3 witnesses that they offered in their case,
I need to hear an argument based on the witnesses actually called in the city's case and what they said. It needs to rebut a thing that was said by a witness in the city's case to be proper rebuttal.
Can I look at my notes for a minute?
Sure.
Okay. Should we go through the remaining jury instructions?
Sure. Okay, the good faith presumption, well, you can tell by the fact that my hand, I have a lot to say about this. This is tricky, because I think the city's argument that the Rich v. Cooper case is based on just an amount of force used analysis is right, and that it possibly is a presumption that can be kind of imported into other police uses of force. However, this is a really tricky instruction because it has the feel of a comment on the evidence. And so I am thinking about giving it, but I think if I give it, it needs to have an extra sentence explaining that it's a rebuttable presumption and that it's up to the jury to decide if it applies based on the totality of the evidence.
I think that what you just said is fine.
Okay.
Because I think it is a rebuttal, like every presumption.
Your Honor, I was unable to find any case, state or federal, that ever offered this instruction relating to simply a use of force. The case in question, Rich v. Cooper, is
about an arrest. I agree.
Solely constrained to an arrest. There's no question. There's no arrest here. The only case that actually determined, something outside the scope of an arrest is a federal case that had to do with a brief detention. And that case specifically said the holding of Cooper is constrained to an arrest and has never been used to apply to anything beyond that. And we declined to apply it to a situation of a brief detention of a person that did not give rise to an arrest. So, this is straight out of 1963, but the idea that a jury would be told in 2022 that a peace officer is presumed to be acting in good faith when they use physical force against a person they're not arresting, is unaccountable.
Sure. So I've told you what I'm going to do. I know you object and you'll make your exception. And
Okay.
I don't entirely disagree with you, but the legal reasoning of Cooper, I think there's a legitimate argument that it's broader, that it's the use of force that's at issue. And so, so we don't even have to agree to disagree.
I know.
We agree and we disagree, and we just have to move on. And so, did you get that sentence?
I have, this is a rebuttable presumption, and it is up to the jury to decide if it applies based on the totality of the evidence.
Okay, and then, I'm gonna give police officer authority to restrict access to certain areas. And I'm gonna give the instruction on authority to arrest for city code violations, and I'm gonna give the no duplicative damages instruction. And I think that maybe no duplicative damages needs to come after the verdict instruction. And then the verdict instruction and the duplicative damages instruction need to go at the end. Okay, I have no doubt.
73.01 damages avoidable.
That's, I'm giving that, that's, yeah, okay. That's an easy one.
Your Honor, are we gonna look at the reasonable force / justification instruction and how that would play into the verdict form?
We're not, so here's my plan. The verdict form needs work. I'm not willing to keep the jury waiting while I work on the verdict form. And so what I want to do is just read the verdict form to them at the end of the closings. Unless, I mean, you probably want to show it to them, but you're just going to have to do without it and just explain what they need to decide. Mr. Manlove?
Will we be provided copies of the jury instructions?
Of course, of course.
Prior to reading them?
Yes. Yeah.
I just wanna go through them.
Okay, and so, Mr. Burgess, did you come up with something more you can tell me about why your
Well-
preferred witness is proper rebuttal?
Well, so, I mean, I think that the questioning of Mr. Wenzel and Ms. Wenzel were pretty broad in terms of covering the use of force that occurred after the police came over the shield wall, and the degree to which, I mean, they were attempting to show that it was essentially that force was being reasonably used here. They called a witness who literally discussed the entire night's actions in what can only be described as granular detail from
Sure.
the beginning of the
But
night all the way
how-
until the end.
So just the fact that your witness has something to say on the subject of a subject that Mr. and Mrs. Wenzel were examined about, whatever he has to say or authenticate has to rebut what they said.
Right. Well, so
And I'm guessing that it doesn't, because I feel like
he put on evidence
go
regarding,
witness.
Commander Dobson was testified about about their concerns and why they did what they did and why they were doing what they were doing on the bridge and everything that occurred before that. And I think that this testimony shows that what they were doing was actually motivated by something else other than their concerns about paintball. A show of force and violence during the protest was, in fact, what was going on throughout the night.
What's in the video? Have I seen this video?
I don't know that it was shown because I think based on your ruling, my inability
Can you
to...
show me the video?
Yeah. Paul, can you show Exhibit 2?
Yeah.
And I expect beyond just the video that he would...
And then just,
I'll
I
stop.
know I'm jumping around, but Mr. Burgess, do you have an estimate on your closing?
I did a run through this morning, and I think it was about... I think it was about 15 to 20 minutes. Well, I have some videos to show.
Okay.
I think that's probably sufficient. So that was our proposed Exhibit 2.
What's, I mean, I know I just saw it, but what's in it? What's the important part?
The important part is where Craig Lehman gratuitously comes out of nowhere and shoves a person who's clearly designated as a press member to the ground from behind.
Okay, and so what time is this video taken?
I'd have to,
Can you show me that part again?
Disperse to the east immediately.
Sure, I do want to know like when in the evening this was.
So this,
No?
we believe that this was after the window that we're talking about, that this was about 12:40. This is sort of after plaintiffs 13 and 12 and 13, I think. It's coming east on Lombard from the I-5.
Okay, so I don't think this is proper rebuttal unless Commander Dobson said this didn't happen or no one was doing this. I don't remember him saying no one was doing this. Is there something in his log that you think this rebuts?
well, I'd have to look, Your Honor, but
Okay.
I do think that the court has pretty broad discretion about allowing testimony.
I disagree. And so is there something you have read that says that?
Well, when I looked up the subject of rebuttal, I don't believe there's an Oregon case that actually addresses what is the
I think
scope
there's a
of.
rule, but I'm not
Your Honor, may I
exactly sure
suggest,
where it is.
Lehman, he called Lehman, subpoenaed Lehman, Officer Lehman in this case.
Lehman said, are you really going to bring up Craig Lehman right now?
No, we're not getting into this.
Okay, all right.
Okay.
Commander Dobson, may I speak?
Oh, sure, yeah.
You know, he never said that the police didn't push people. He never said the police did not push people down to the ground. He never said that the police didn't push people from behind. You know, if Commander Dobson had said something like that, then maybe this would be proper rebuttal. But that certainly, he never said anything like that. So it's at the city's position that this is not proper rebuttal. The questions to Mr. Wenzel and Miss Wenzel were extremely limited. With Miss Wenzel, I asked her, did you make an IPR complaint? And did you take a video? Did you give it to your lawyer? And then Mr. Wenzel was related to Miss Wenzel's alleged injuries and his, the accusations of the assault against Officer Floor.
Your Honor, I think you're talking about trial procedure, Rule 58. Parties respectively may introduce rebutting evidence only unless the court, in furtherance of justice, permits them to introduce evidence upon the original cause of action, defense, or counterclaim.
Which rules?
58B, it also says manner of proceedings on trial by the court. Trial by the court shall proceed in the manner prescribed in sections 3 through 6 of section B of this rule unless the court for good cause stated on the record otherwise directs. So plaintiff's argument would be that I think good cause is shown because, one, I was not able to effectively call Mr. Lehman as a witness, which is when I would have brought this video up. The reason being that he engaged in a tactic to avoid trial by refusing to testify at his deposition and then changing his stance and showing up without a lawyer, without ever telling me or opposing counsel about it. So I think that the behavior of Mr. Lehman and his counsel, which led to the reading of an instruction to the jury, warrants good cause enough to allow me to put on evidence to impeach him at this point. Two, I didn't have the evidence where we're talking about a thing that was largely almost not filmed at all with respect to any of the uses of force that night by the police themselves. They had no body cameras. Almost all of the footage was taken by people who informally reported on it through Twitter and Instagram and other things that people under 35 know what they are. And I think that plaintiff should be able to put on this evidence because it's evidence of what the officers were up to that night.
So, Mr. Burgess, I am sympathetic to your position, but the reality is we're on day 6 of a trial that was estimated to be 5 days. And I don't regard this, and, this is how I look at this in every case. I don't think this is proper rebuttal because I think that rebuttal testimony in general, and there's lots of Oregon Supreme Court case law on this, it's limited to evidence made necessary by the opponent's evidence. And I don't think this was made necessary by the city's case. And you elected not to call Officer Lehman and to read a stipulated statement about that. And so I understand the trouble I am causing with this ruling, but that's my ruling and that's the rationale for it. Honestly, I think you don't need it. You have enough videos of the night of people being pushed.
So those are the.
Your Honor, if we're moving straight to closing, well, I guess we're doing instructions
Yes.
first. Okay,
Yeah.
okay.
Let's take a, Mr. Manlove, I want to take a break, but do we need to talk about something before we take a break?
I was gonna ask for a break.
Yeah, no, let's take a break. Please skim through the instructions. I will
Are they
do that.
available? Are,
I have them here.
Okay. Yeah, so we're on a break for a few minutes here. Yeah, it's gonna be. I know that they're really trying to. It seems like they're really trying to get the trial side of things wrapped up before lunch. Probably, hopefully, trying to do the trial and the jury instructions so that after lunch they can start deliberations. That said, it's going to be a few minutes. I'm going to go ahead and turn the music on, and then when they come back, we'll come back.
They look, just in a cursory review, they look complete as we discussed.
Okay.
And as the court ruled.
Is the stipulation of fact instruction in there with the?
No, those are added on to the list.
Oh, great. Okay, perfect. Okay. Okay.
In a second here, Your Honor. I guess the concept, I thought we might have some kind of instruction that says, that references the stipulation of fact document. And I'm not sure where that would be. Something to the effect that the parties have agreed to certain stipulations of fact, and this is be presented to you as a court exhibit, rather than me reading all of them to you.
I have a sticky note and I'll just tell them that.
Yeah. Okay. Thank you.
Okay, and I'm gonna ask them, so I have a thing to do at noon sharp, so we need to take a break no matter how awkward it is. And then, sorry about that. And then I am going to ask them before we start if anyone truly cannot come back tomorrow, because I may have to impanel an alternate. We can't send the jury to deliberate with the possibility that they may not get done today if there's somebody on the jury who really can't come back tomorrow. So and we can talk about what to do later. I just need to know that.
Okay. I mean, I thought the questions to the court early last week were, I think the only restrictions were on Wednesday for.
Oh, yes.
So-
Yes. Thank you. I lost my timeline. You're right. Okay.
So I think we're
Okay.
good. We're good. If we get it to them today.
Okay.
I think they're free for tomorrow.
Okay. Thank you. Thank you for pointing my brain in the right direction.
Yeah, my assistant has reminded me that we do have some exhibits to mark and take care of, including the IC summary and the activity log, but we can do that after.
It seems unlikely to me that we're going to get all through the closings before noon, but
Yeah.
we'll see.
Okay. thank you.
Including rebuttal. So yes, I know that we still need to sort out those exhibits
More housekeeping.
and the verdict form.
You can do that while the jury's deliberating.
Can you
Oh, no, we
print this so these?
So are we
Never mind.
good?
No, we can't do that. What's that?
Oh, I actually already have
Exhibits,
it.
or
now that
does
I
the court
think
need
about it.
anything
Well,
on the
we
record?
still have
Might
to
help
report
me
about what
scribble
she
on
wanted
it.
What the
redact
hell?
from the log.
But you're willing to go with what she wants?
I think generally, I'm trying to find which, because we marked our.
We have a PDF that they sent as well. It looked like it matched to me.
Other than that one, are the rest just housekeeping?
Well, then there's, I think, just a second, which one is it?
The activity log is 102, some version.
No, yeah, no, I got that. The one I'm thinking of is,
Yeah, which one was?
where's defendant's exhibit?
Okay, great.
Here we go.
So John, this was,
So I think this is what I have for 170.
What?
And now I know the stapling's an important step.
Well, with me, yeah, I'm kind of a pig pen.
Your Honor, I think we're trying to sort out whether we need anything on the record for the housekeeping matters with the exhibit. If we do, does that need to come before closing?
And not in my opinion, no.
Okay.
Let me just take a look, because I have a lot less redacted, so.
yeah, let's go through.
Can I get the highlighter? Yeah. Oh, thank you. Can I see yours?
Yeah.
Oh, shoot.
Oops, actually, yeah.
Oh, so I have a problem here with this rocks, lasers. I mean, I don't have a problem with lasers, but nobody testified who was actually present that there were rocks or glass bottles.
Where,
Yeah.
what document?
I'm sorry, I don't know. I was talking to him. I
Oh,
didn't know you
okay.
were.
Okay.
I was being, I was talking about Exhibit 70, sorry, Your Honor, but
Is that the email? Or the...
yeah, it's the email, and my problem is it conflicts with the testimony of the officers themselves who were present that night. None of them, Kammerer testified that a Coke can and water bottles, one of which he said was full, along with paint balloons or bombs and some kind of firework. Here it says in this email, they took, whatever that means, several projectiles, rocks. There was nobody testified about a rock. And yeah, but Dobson was by the airport. You can't smuggle in this outrageous testimony for which there was no witness.
We'll talk about it later.
Oh.
Please be seated. Good morning. I am very sorry for keeping you waiting. The good news is I think this trial is absolutely on schedule. I don't know what will happen with the length of deliberations, obviously, but there is some possibility you could be done today. I think that you will get the case to begin deliberating on today, probably in the early afternoon. So it would be very unusual if you were not able to get the case done by tomorrow. So I think we're on schedule. And I want to give you a little bit of information about what to expect going forward until you deliberate. So what I need to do is read to you the legal instructions you need to decide the case. I mentioned previously that you will get them all in hard copy paper form, so don't just work on listening. I think that works better than trying to get down every detail. I will let you know that they are a long set of jury instructions for a trial, and so I think they may take me 25 minutes or more to read, and that's a long time to be listening to legal instructions, and I just want to acknowledge that and say thank you for your attention. After that, we will move into the closing arguments of the parties, and Mr. Burgess will give the closing for Mrs. Wenzel, and then for the city, the closing will be given by Ms. Turco. And then because Mrs. Wenzel, as the plaintiff, has the burden, Mr. Burgess will have an opportunity to make a brief rebuttal argument. So you'll hear from him twice, and it'll be sort of a sandwich format. I think it's unlikely we will get through all of that before noon. And so I think some of that will happen after noon, after you have a lunch break. And then after you hear the closings, we will give the case to you to deliberate on, and you'll have your notebooks and all of the exhibits, and I will discharge. We have one alternate remaining. We lost a juror already due to what sounded like a serious health issue, not related to COVID. And so there's one alternate who will be discharged before the deliberations. And we will let that alternate absolutely know what the verdict is when we have it. And we'll also let the other juror who was excused know. So I am going to begin reading the instructions. And some of this at the beginning may sound familiar, and then very quickly we'll move into the more specific instructions for this case. It is your responsibility solely as the jury to make all decisions about the facts in the case. You must evaluate the evidence to determine how reliable or how believable that evidence is. When you make your decision about the facts, you must then apply the legal rules to the facts and reach your verdict. Remember, however, that your power to reach a verdict in this case is not arbitrary. When the court tells you what the law is on a particular subject or tells you how to evaluate certain evidence, you must follow these instructions. Please do not allow that anything that I have said or done, or the fact that I have given any particular instruction in the case, to suggest that the court has formed any opinion about the case. When I have sustained objections to evidence or ordered that evidence be stricken or excluded from your consideration, you must follow the court's rulings. Do not consider such matters during your deliberations. You need to base your verdict on the evidence and the legal instructions. Again, the attorney's opening statements to you at the beginning and the closing arguments you're about to hear are not evidence. They're intended to assist your understanding of the evidence, but what the lawyers say is not evidence. If your recollection of the evidence is different from the attorney's recollection, you must rely on your own memory or understanding of the evidence. In deciding the case, you as jurors are to consider all of the evidence that you find worthy of belief. It is your duty to weigh the evidence calmly and dispassionately and to decide the case on its merits. Do not decide the case on guesswork, conjecture, or speculation. You should make every effort to be aware of your biases, including unconscious biases, and what effect they may be having on your decision making. In your deliberations, please do not be biased in favor of or against any party, witness, or attorney because of the person's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, others we may not be fully aware of. These hidden thoughts can affect what we see and hear, how we remember what we see and hear, and how we interact with others, and also how we make important decisions, which is, of course, what you are all here to do. All parties are equal before the law, so please do not allow any personal feelings, sympathy, prejudice, or bias, whether conscious or unconscious, to influence your decision making. Generally, the testimony of any witness whom you believe is sufficient to prove any fact in dispute. You are not simply to count the witnesses, you are to weigh the quality of the evidence. Please keep in mind that each party is entitled to the considered decision of each juror. Therefore, you should not give undue weight to another juror's notes if those notes conflict with your recollection of the evidence. And I am going to read these instructions to you, and I'm also going to read the titles, which I think kind of helps orient you to what you're about to hear. So this is an instruction on how to view evidence. Evidence can come in many forms. It can be testimony about what someone saw or heard or smelled. It could be an exhibit admitted into evidence. It can be someone's opinion. Some evidence may prove a fact directly, such as testimony of a witness who saw a jet plane fly across the sky. Some evidence may prove a fact indirectly, such as testimony of a witness who saw only a white contrail that jet planes often leave. This indirect evidence is sometimes referred to as circumstantial evidence. Either way, the witness's testimony is evidence that a jet plane flew across the sky. As far as the law is concerned, it makes no difference whether evidence is direct or indirect. You may choose to believe or disbelieve either kind of evidence. Whether it is direct or indirect or direct or circumstantial, you should give all evidence whatever weight you think it deserves. Evaluating witness testimony. The term witness includes every person who has testified in this case. Every witness has taken an oath to tell the truth. You may believe everything a witness says or part of it or none of it. In considering the testimony of any witness, you may take into account the opportunity and ability of the witness to see, hear, or know about the things the witness told you about, the witness's memory, the witness's manner while testifying, the witness's interest in the outcome of the case, and any bias or prejudice that witness might have, whether other evidence contradicted the witness's testimony, the reasonableness of the witness's testimony in light of all of the evidence. This is an instruction called witness false in part. A lie is a false statement made with the intent to deceive. A witness may be mistaken, confused, forgetful, or contradict themselves or other witnesses without lying. If you find that a witness has lied in some part of their testimony, then you may distrust the rest of the witness's testimony. You have the responsibility to determine what testimony or portions of testimony you as the jury will believe. Physical facts. Your factual conclusions cannot be based on evidence that is contrary to established physical facts. This is an instruction on expert witness testimony. You heard from some expert witnesses. I think they were all medical in this case. An expert witness may give an opinion on any matter in which that witness has special knowledge, skill, experience, training, or education. The opinion may be given in response to a hypothetical question. A hypothetical question asks a witness to assume that certain facts are true and then to give an opinion based on those assumed facts. You should consider the qualifications and credibility of the expert witness, the reasons given for the opinion, and the reasonableness of any assumptions underlying the opinion. You are not bound by the opinion. Give it the weight, if any, to which you as the jury consider it entitled. Evidence received for a limited purpose. The court received evidence of Exhibit 10, which is a video, for a limited purpose. You may consider it only for the purpose of plaintiff's negligent training claim, not as evidence that may be considered for proving plaintiff's assault or battery claim. And Exhibit 10, you'll have that in evidence. I think that was the video we saw the most that the legal observer took. Oral admissions. Statements made by the plaintiff or the defendant that are unfavorable to that party are called oral admissions. A witness's testimony or other evidence about such statements is to be viewed with caution. In evaluating testimony or other evidence about an oral admission, you should consider two things: whether the statement was clearly and understandably made by the plaintiff or the defendant or the defendant's agent, and whether the language is correctly remembered and accurately reported by the witness. You will also receive an exhibit in evidence that you haven't seen before that is about factual stipulations between the parties. So the parties have agreed on certain facts that you need to treat as conclusively established, and they have agreed to put the factual stipulations on a document that can be entered as an exhibit rather than have me read it out loud to you. It's very long. So when you get that document entitled factual stipulations, you need to take a look at it, maybe have somebody read it out loud and treat the factual stipulations there as proven. This is an instruction called less satisfactory evidence. In evaluating the evidence, you may consider the power of each side to produce evidence. If weaker and less satisfactory evidence is offered by either party, when it appears that the party could have produced stronger and more satisfactory evidence, the evidence should be viewed with distrust. This is an instruction called burden of proof. A party must prove any claim that party has made. This is called the burden of proof. In this case, the plaintiff must prove the plaintiff's claim by a preponderance of the evidence. In this case, the defendant must prove the defendant's affirmative defenses by a preponderance of the evidence. Here is a definition of what preponderance of the evidence is. When a party must prove a claim by a preponderance of the evidence, that party must persuade you, the jury, by evidence that makes you believe the claim is more likely true than not true. After weighing all the evidence, if you cannot decide that something is more likely true than not true, you must conclude that the party did not prove it. You should consider all of the evidence, no matter who produced it. The City of Portland acts through its agents. A city can act only through its officers, agents, or employees. An action by the police officers of the city is the act of that city if the act was within the scope of that person's authority. There are three claims you need to decide in this case. There's a negligent training claim, an assault claim, and a battery claim. And the next set of instructions I'm reading you are with regard to the negligence claim. So this is the negligence claim instruction. The law assumes that all people have obeyed the law and have been free from negligence. The mere fact that an accident or injury occurred is not sufficient by itself to prove negligence. It is, however, something you may consider along with other evidence. The plaintiff has made a claim for negligence against the defendant. Specifically, the plaintiff alleges that defendant was negligent in its training of Portland police officers with respect to pushing people with batons during a dispersal situation. This requires the plaintiff to prove each of the following. The defendant's conduct was negligent, the defendant's negligent conduct was a cause of harm to the plaintiff, and the harm was reasonably foreseeable. Negligent conduct defined. The law requires every person to use reasonable care to avoid harming others. A person's conduct is negligent if that person fails to use reasonable care. Reasonable care is the degree of care and judgment used by reasonably careful people in the management of their own affairs to avoid harming themselves or others. A person fails to use reasonable care when that person does something that a reasonably careful person would not do, or fails to do something that a reasonably careful person would do under similar circumstances. In deciding whether a person used reasonable care, consider the dangers apparent or reasonably foreseeable when the events occurred. Do not judge the person's conduct in light of later events. Instead, consider what the person knew or should have known at the time. This is the definition of the term foreseeability. A person is liable only for the reasonably foreseeable consequences of his or her actions. There are two things that must be foreseeable. First, the plaintiff must be within the general class of persons that one reasonably would anticipate might be threatened by the defendant's conduct. And second, the harm suffered must be within the general class of harms that one reasonably would anticipate might result from the defendant's conduct. Right to assume the law obeyed. Every person has a right to assume that others will obey the law unless and until that person knows or in the exercise of reasonable care should know otherwise. Comparative negligence. The law provides for comparative negligence. This means that you are to determine each party's negligence, if any. Comparative negligence. The plaintiff and the defendant have each alleged that the damage was caused by the other's negligence. If you find that both the defendant and the plaintiff were negligent and that their negligence caused the alleged damage, then you must compare the negligence of the plaintiff to the negligence of the defendant. In making this comparison, you must measure the percentage of negligence of each and not the percentage of damage caused by each. The comparison of negligence must be expressed in terms of percentages that total 100%. If the plaintiff's negligence is more than 50%, then your verdict is for the defendant. On the other hand, if the plaintiff's negligence is 50% or less, then your verdict is for the plaintiff. Do not reduce the amount of the plaintiff's damages, if any, as a result of your comparison. I will reduce the amount of your verdict by the percentage of the plaintiff's negligence, if any. Here is a definition of the term causation.
Your Honor,
Yes.
I have a matter.
Sure.
As I understood, there was going to be another sentence in the
Yes. So this will be clear on the verdict form, but comparative negligence, as asserted by the city as a defense, is only applicable to the negligence claim. There are two other claims in the case, assault and battery, and they are for intentional conduct. And so the comparative negligence or comparative fault defense of the city does not apply to the battery claim or to the assault claim, only to the negligent training claim. And the lawyers will talk to you more about that in their closing arguments, and it will be clear on the verdict form that the comparative negligence defense only applies to one of the claims, not all three of the claims. So now I'm going to read to you an instruction on causation. Many factors operate either independently or together to cause harm. In such a case, each may be a cause of the harm, even though the others by themselves would have been sufficient to cause the same harm. If you find that the defendant's act or omission was a substantial factor in causing the harm to the plaintiff, you may find that the defendant's conduct caused the harm, even though it was not the only cause. A substantial factor is an important factor and not a factor that is insignificant. So now I'm moving on to the elements of the claim of assault. So this is the second claim in the case. The plaintiff claims that the defendant or the defendant's police officer agent assaulted her. This requires the plaintiff to prove that the defendant acted through its agent, a police officer, intending to either cause harmful or offensive contact with the plaintiff or cause the plaintiff apprehension that the defendant's agent police officer was going to cause an imminent harmful or offensive contact with the plaintiff. And the plaintiff reasonably believed a harmful or offensive contact would occur. This is an instruction for the claim of battery. So this is the third claim in the case. The plaintiff claims that the defendant committed a battery. A Portland police officer is justified to use reasonable force to accomplish an official purpose, such as dispersing an unlawful assembly. To prove a battery, the plaintiff must prove the following: that one or more Portland Police Bureau officers used unreasonable force against the plaintiff. 2, that the police officers acted intending to cause harmful or offensive contact with the plaintiff. And 3, the police officers' actions directly or indirectly caused a harmful or offensive contact with the plaintiff. Here is a definition for the term intent, as I have just used that. Intent means either the actor desired to cause the consequences of their actions, or 2, the actor believed that the consequences were substantially certain to result from their actions. This is an instruction on damages. If you find that the defendant is at fault, then you must decide whether or not the plaintiff has been damaged, and if so, the amount of her damages. The fact that I am instructing you with respect to damages is not to be considered by you as an attempt by the court to suggest or indicate that you should or should not award damages, nor should the amount claimed for damages by the plaintiff in the complaint be considered by you in arriving at your verdict, except in one respect. That is, the amount of damages claimed by the plaintiff is the maximum amount that the jury can award to the plaintiff if the jury decides to award damages to the plaintiff. There are 2 types of damages alleged in this case: economic and non-economic damages. And I'll read you instructions on what those are in a little bit. Of these 2 types of damages, you should consider those which you find to have been sustained by the plaintiff as a result of the defendant's fault. The plaintiff must prove economic and non-economic damages by that same preponderance of the evidence standard. This is an instruction on economic damages. Economic damages are the objectively verifiable monetary losses that the plaintiff has incurred. In determining the amount of economic damages, if any, consider 1, the reasonable value of necessary past and future medical, hospital, nursing, rehabilitative, and other health care and services for treatment of the plaintiff, and 2, the amount of lost income incurred by the plaintiff since the injury to date. In this case, the total amount of economic damages that could be awarded by the jury may not exceed the sum of $15,606. Here is an instruction on non-economic damages. Non-economic damages are the subjective, non-monetary losses that a plaintiff has sustained or probably will sustain in the future. The law does not furnish you, the jury, with any fixed standard by which to measure the exact amount of non-economic damages. However, the law does require that all damages awarded be reasonable. You must apply your own considered judgment to determine the amount of non-economic damages. In determining the amount of non-economic damages, if any, consider each of the following: the pain, mental suffering, emotional distress, or humiliation that the plaintiff has sustained from the time she was injured until the present, and that the plaintiff probably will sustain in the future as a result of her injuries. And 2, any inconvenience and interference with the plaintiff's normal and usual activities apart from activities in a gainful occupation that you find have been sustained from the time she was injured until the present, and that the plaintiff probably will sustain in the future as the result of her injuries. The amount of non-economic damages claimed by the plaintiff and that could be awarded by the jury may not exceed the sum of $450,000. Damages avoidable consequences. A person who suffered damage has a duty to exercise reasonable care to avoid increasing that damage. There can be no recovery for increased damage caused by the failure to exercise such care. Passive resistance. Passive resistance under the law is non-cooperation with the lawful order of a police officer that does not involve violence or active conduct. Active conduct is the obstruction of the work of the government or police officers through active physical conduct. Authority to direct traffic on public rights of way. Officers and reserve officers of the Portland Police Bureau are authorized under the law to direct pedestrian and vehicular traffic on any public right-of-way. Pedestrians. No person with the intent to interfere with the free ingress to or egress from shall block or attempt to interfere with or block pedestrian or vehicular entrances to public or private property abutting the public sidewalk. Authority to disperse. Under Oregon law, police officers have authority to disperse unlawful assemblies and to use reasonable force under the totality of the circumstances to effectuate the dispersal. Reasonable force. Under Oregon law, a peace officer or police officer acting in the course of their official duty cannot be held liable for the claims of assault or battery unless an officer uses excessive force. When physical force exerted by the officer against the plaintiff was no more than necessary to accomplish the legitimate purpose of fulfilling the officer's duty, the force was reasonable and the officer did not commit battery or assault. Reasonable force is that force which is no more than necessary to accomplish the legitimate purpose of fulfilling the police officer's duty, considering the totality of the circumstances confronting the officer. If you find that the police officers in question used reasonable force against the plaintiff, that is a complete defense to the claims of assault and battery. Good faith presumption. A peace or police officer is presumed to be acting in good faith in determining the amount of force necessary to accomplish an official purpose, and an official purpose could be dispersing an unlawful assembly. This, under the law, is a rebuttable presumption. So what that means is it is up to the jury to decide if it applies based on the totality of the evidence in this case. Police officer authority to restrict access to certain areas. Whenever a threat to the public health or safety is created by an emergency, a Portland police officer may restrict or deny access to any persons to the area where such threat exists for the duration of such threat when the officer reasonably believes the presence of such persons would constitute a danger to themselves or others, or would substantially interfere with the performance of the police or other emergency services. For the purposes of this section, an emergency includes a riot, a civil commotion, or mob action. Restrict or deny access means that a police officer has the authority to regulate or prohibit the presence or movement of persons to, from, and within any area until the reason for such restriction or denial of access no longer exists. It is unlawful for any person to enter or refuse to leave any area closed or restricted in access pursuant to an order from a Portland police officer. Police officer authority to arrest for violations of the city code. Police officers of the City of Portland are authorized to arrest, cite, or take other enforcement action against persons who fail to obey police orders or commands regarding the direction, redirection, limitation, or restriction of access to public rights of way or certain areas where the threat of an emergency exists. Okay, got just two more to read to you. Home stretch. Okay, this is an instruction on the verdict. When you return to the jury room, and I think we're talking about after lunch here, select one of your members to act as presiding juror. The presiding juror is to participate like all other jurors and has no greater weight or voice than any other juror. After selecting your presiding juror, deliberate until you reach your verdict. You may conduct your deliberations any way you wish, but most juries find it helpful to discuss the evidence before taking any votes. You will get the verdict form at the close of the closing arguments, and I'm thinking that's after lunch, and I'll read it out loud to you. When you have the verdict form, you need to answer the questions according to the directions on the form and the legal instructions that I give you, and you need to read the instructions correctly, because depending on how you answer certain questions, you may go to the next question or you may skip to a question further down the page. This is a civil lawsuit. So in the verdict form, at least the same 9 jurors must agree on each answer unless the verdict form instructs you otherwise to a particular question. So another way of saying that is your verdict does not have to be unanimous. Not everybody has to agree, but at least the same 9 jurors have to agree one way or the other on the questions. When you have answered each question on the verdict form, you are required to answer, and you have a lawful verdict, meaning at least you have at least 9 jurors who are agreed in the same way on each of the questions. Your presiding juror should insert the answers on the verdict form, sign and date the verdict form, and then let us know that you have a verdict. Once we have your verdict, we'll get everybody back in court. Sometimes that takes a little while, and the presiding juror will give the verdict form to Anna. Anna will give the verdict form to me, and then I'll read the verdict form in open court. In reaching your verdict, you need to understand that there are not duplicative damages in this case. So you are instructed that you cannot award duplicative damages on multiple claims. You can only compensate plaintiff one time for an injury. In other words, you cannot award damages for the same injury on more than one of plaintiff's claims. And so, and I may talk more about that later when we have the verdict form. At this point, we will move on to the closing arguments.
Can I move this around?
Oh, you can, yes.
Thank you. Good morning. I want to thank you for your attention to this case. I know that it has gone on for quite a while, and there's been a lot of evidence and testimony, and unfortunately quite a few breaks where you guys no doubt had to sit and wonder what's going on. At the beginning of this case, I told you what the evidence would show, or what I believed it would show, and I'd like to go through some of that evidence with you now and sort of see where we're at now that we've looked at all of the testimony and heard the testimony and seen the evidence. As I said would happen, Ms. Wenzel testified that she went to the protest as a medic, that she put tape on her helmet on both sides to prominently display that she was a medic, and that her purpose for being there was to help people and to assist somebody who was injured if that happened. She had a backpack with a kit, with first aid supplies. She also had an insignia on her backpack. In fact, Mr. Manlove, during his examination of Ms. Wenzel, identified her in all the photographs by pointing out the prominently displayed red cross on her helmet, which no doubt everyone there also saw. None of this is disputed. No evidence came in to the contrary. After the initial meeting at the park, she walked along with the protesters. I'd like to show you again the video that was admitted as Exhibit 1. which shows her walking at the beginning of the protest shortly before the confrontation with the police. You will see her come into frame after a few seconds. I'll point her out. See her right there at the bottom of the screen, adjusting her glove. See that she's walking. There's no hostility or aggressiveness in her posture. She's just walking along with a group of protesters. You heard testimony that the protesters left the park and began marching, and at some point the protesters were blocked by the police and prevented from going any further. I'd like to stop here and address one issue that was, I think, unclear in the defendant's case, which is the officers spoke as though they blocked the protest because of the unruliness of the crowd, but that's actually the reverse of what happened. They blocked the protesters because they didn't want them to continue any further, and then some members of the crowd became unruly. But again, there's no testimony that Ms. Wenzel did anything like that. She didn't throw anything. She didn't have a weapon in her hand. She didn't shout insults at officers or attempt to resist anybody. So the police initiated a standoff with the protesters, and then after a fairly brief period of time, charged at the wall that had the shields that you saw, and they, some of them running at full speed and launching themselves into the protesters that were at the front line. The video confirms exactly what Ms. Wenzel said happened at that point, which is that smoke grenades were shot into the crowd and that she lost track of her husband who had been standing next to her, and that she began dispersing in the direction that the officers were directing the crowd to disperse. Shortly after this, we showed a video that was previously admitted as Exhibit 14, which shows Ms. Wenzel moving along in front and behind of an officer who is directing and pushing her to go in a certain direction. Go ahead. See her come to frame right there. And she's pushed once, and she's pushed one more time, and they continue down the street. And I think that this video is helpful for a few reasons. First, what you can see of her is that she is complying with the order to disperse. She's not fighting with anyone. She's not. She doesn't have a weapon in her hand. She's not throwing things at the police or yelling insults or anything like that. In fact, she's just proceeding in the direction that she's being ordered to go. Also, what's helpful is that it shows how crowded the street and sidewalks were at this point, and how difficult it would have been to just leave this area without dispersing in the direction the officers are telling you to go. I think it's important at this point to be reminded of the fact that the officers that did testified that doing what you just saw in that video, which is walking forward and doing what the officers are telling you to do, would not justify running at somebody at full speed and knocking them to the ground with a baton.
I have a confused now.
So they agree that what she's doing in that video that you just saw wouldn't warrant the use of force. What they're asking you to do is to imagine that shortly after this video, she flipped a switch and became a different person, and she must have done something that would have warranted running at her and knocking her to the ground from behind.
Yeah, it would work.
Also, I think it's helpful, and you'll have that video to look at when you're in the jury room deliberating. is that some of the officers have helmet numbers on the back of their helmet, and some of the officers don't have any number at all, but they're all wearing head-to-toe black riot gear with helmets that obscure parts of their head and parts of their faces, and they have visors over their faces. They have no name tags or anything to identify them apart from some of them having a number on the back of their helmet. Short of a miracle, there would be no way to identify an officer that ran up behind her and knocked her to the ground, unless that person admitted to doing it or identified himself. As Lieutenant Shaning's testimony makes clear, all of these officers were Portland Police Bureau officers, and they were in fact all members of the Rapid Response Team, or RRT. We know that the officer that slammed her to the ground was a Portland Police Bureau officer, and that he was a member of the RRT. Finally, when you see the video again, I want you to really look at her demeanor in the video. She appears maybe slightly confused and stunned at the situation, but there's no hostility. There's no aggressiveness. There's nothing going on in this video that would suggest that she is or was about to do anything that would warrant that kind of use of violence against her. So shortly after that video, while she was going along with the crowd, and as you saw, and we'll talk about Exhibit 10 in a minute, as they work their way into the neighborhood, you know, there's trees, so it gets darker. But as this is happening, she is moving along and is near the sidewalk, and an officer begins running in her direction, which she sees over her shoulder. She doesn't think that this person is running at her because she isn't doing anything wrong, which was a mistake, because it turns out this person ran directly at her, and while she was facing away from the officer, slammed into her from behind with a long object that was likely a baton, and launched her in the air, and where she landed on her outstretched arm, and then on her helmet and face gear, and then lastly, her feet. No part of that story that I just told you, no part of that recitation is disputed by any witness offered by the city. Nor do they offer any reason to dispute it, really. As Dr. Baskerville explained, she broke her right radial head, which is basically at the elbow. And this injury is typically associated with a fall on an outstretched arm. He testified that this would usually occur from a fall from a height, like off a ladder or a bike. And he testified that healthy adults without underlying conditions like osteoporosis typically don't suffer from that specific kind of break just by falling from a standing height. And he testified that she suffered soft tissue damage in her elbow, which along with the break was consistent with being shoved from behind and falling on her outstretched arm. In fact, even the doctor hired by the defendant agreed that being shoved from behind and falling onto the ground would cause this injury. Ms. Wenzel then gets up and keeps going. And at this point, she is in shock, and the pain is not quite set in. She keeps going and is knocked into by a protester, which causes her to inadvertently bump into an officer that is walking beside her. The officer then, without saying anything and without any reason, strikes her in the leg with a baton, again knocking her to the ground and badly skinning her knee. None of this is disputed, nor has any reason to dispute it been given by the city. She suffered the injury, and you saw photographs of her skinned knee with bruising next to it, which you will also have access to when you're deliberating. And we should also pause for a moment and contemplate that Ms. Wenzel did not grab the officer. She didn't shove an officer. She didn't hit an officer. She bumped into somebody that was running next to her in a crowd. None of the witnesses offered by the city have testified that this was a reasonable thing to do, or that this was within City of Portland's policy regarding use of force to just lash out and strike somebody with a baton while they're running. There is no justification for that kind of violence. Ms. Wenzel then kept going, and when she was able to get away, she called her friend, the nurse, Beth Champion, whom you heard from. She testified that Erin shared her location with her phone, and Ms. Champion came and met her near the protest. She testified that Erin looked injured and in shock, and that Erin told her that she had been shoved from behind by an officer, and that she had fallen to the ground and was hurt. Ms. Champion tried to convince her to go to the emergency room because Ms. Wenzel appeared injured, but Ms. Wenzel just wanted to find her car and get out of there. I think is an understandable feeling many of us have had. Ms. Wenzel then got in her car and started driving, thinking that she could get home, and then realized that that was a mistake and that she needed to go to the ER, which she did. And then when she got there, she was treated for a broken arm and her arm was placed in a sling. Later, she learned that she had a fractured elbow. Her other arm was hurt and was sore, but luckily for her, it was not broken. She was placed on work restrictions and was off work for approximately 8 weeks. The parties had stipulated that that amount of wage loss would be $6,088. She underwent physical therapy and received other medical treatment for her arm, which totaled $6,377.80, which you will see in an exhibit that will be available to you that sort of sets forth what these bills are. She also testified that these events were extremely upsetting to her, that she felt degraded and humiliated, that she was shocked and angered by being violently attacked twice without warning or provocation. She also developed PTSD, which even the city's own expert agrees was caused in part by the physical trauma of being attacked by the police on that night. You were just read an instruction called causation substantial factor, and I want you to take a look at that when you're considering the PTSD issue relating to her claims. Defendant, during its examination of its expert, appeared to be arguing that she could have developed PTSD even without the physical trauma of being attacked by the police, and that her history of depression and anxiety somehow predisposed her to suffering from PTSD, meaning that it really wasn't the city of Portland's fault because of what its officers did. So I want you to look at the causation substantial factor jury instruction, which says many factors may operate either independently or together to cause harm. In such a case, each may be a cause of the harm, even though the others by themselves would have been sufficient to cause the same harm. If you find that defendant's act or omission was a substantial factor in causing the harm to the plaintiff, you may find that defendant's conduct caused the harm, even though it was not the only cause. So Dr. Best testified that there were other things contributing to her development of PTSD. But what's clear is that even Dr. Best's testimony is that the traumatic events of that night were a substantial factor in her developing PTSD, from which she still suffers today. Second, the defendant takes the plaintiff as he finds her, right? If a driver runs into an older woman and she breaks her hip, he doesn't get to say, well, if she was a 20-year-old athlete, she wouldn't have suffered from those injuries. You take her as you find her. Next time, drive better, right? The same with Ms. Wenzel. You don't want people to develop PTSD? Don't randomly traumatize people by attacking them with batons. That's on the police, not Ms. Wenzel. Dr. Best also agreed that the treatment she received was necessary for her condition, and the parties agreed that the amount of her medical bills for her psychological treatment was $3,140. It's hard to say exactly what the defense is here. We don't know who the officer was who attacked Ms. Wenzel, but we do know it was an RRT member. Defendant has not put on any witness that said, I used force against her because she was resisting officers or engaging in assaultive behavior or anything like that. They want you to think that an RRT officer would not do that. To assess a claim like that, we need to look at how the RRT officers were behaving that night. You have seen video of officers shoving protesters to the ground without any provocation or explanation. Well, can you show exhibit 10 starting at second, I think, 20? Pause right there, would you? Thank you. Thank you. So Officer Taylor, that individual right there in the middle, admits this is him, but offers no explanation why that use of force was justified other than that she was in the street. And if you recall from the testimony of other officers, including Kammerer and Lieutenant Shaning, that simply being in the street under City of Portland's use of force policies is not enough to shove somebody to the ground. Now, Detective Kammerer, who was nearby and was Taylor's squad leader, didn't see anything wrong with that video when he saw it. In fact, he could not even bring himself to admit that Taylor had shoved her to the ground. I want to show you what Kammerer describes as somebody tripping on the sidewalk. You could rewind about 10 seconds, maybe, yeah, and play it in at 2/3 speed. So, you have to ask yourself what kind of person would watch that video and say that she tripped on the curb instead of what you actually saw, which is somebody being shoved to the ground by any measure. And this is the person who was supervising these people in the field. He was the squad leader. If he tolerated that and would come in here and minimize and defend it, what was he telling the officers when he wasn't on video? What else did he permit under his watch? Ms. Collins, who you heard from very early on in this case, who took that video, testified that this was not an isolated event. That the officers during that exact push were indiscriminately shoving and brutalizing protesters, whether they were on the street or the sidewalk. That it didn't matter if they were press members or medics like Ms. Wenzel or legal observers like her. I also showed you exhibits 11 and 12, which show another officer, also while Kammerer was present, pointlessly shoving someone without warning to the ground. He walks, the protester that is, in the white shirt, walks out to take photos, it looks like, on his phone, is not even facing the officer, and the officer goes up to him from the side and shoves him hard to the ground. Well, can you show exhibit 12? And start at second Oh, no, I'm sorry, 11. My apologies. You can see it right there.
This is the Portland Police Bureau.
You can see
This is an
the RRT van and this van and the 30 or 40 officers around at the time, none of whom apparently had a problem with that kind of use of force.
Objection, improper argument, states facts not in evidence.
Sustain.
While Kammerer agrees that City of Portland policy says that if someone is just in the street, that is not a justification for slamming them to the ground, it is clear that his officers were doing so with impunity that night. The attacks on Ms. Wenzel were a product of that impunity. In fact, the city has not put into evidence any use of force that was proportionate or justified from that night. Defendant does not have any genuine defense here. They fluctuate between implying that Ms. Wenzel must be lying and that this didn't happen, asking questions of the expert that maybe imply that she tripped, maybe like that woman in Exhibit 10. Or if she was shoved to the ground, there must have been some reason for it. They just can't say what it was. That isn't a defense. It's an avoidance. It is grasping at straws. And in fact, that argument itself, which is gaslighting, is a part of that culture of impunity. They clearly made almost no effort to find out who did this. They reviewed some use of force reports, although it's clear that there was well over 100 of them. It's unclear how many of them they actually reviewed. But in any case, they didn't interview a single person. They didn't show Ms. Wenzel's photograph to a single officer. They didn't email anyone or ask if anyone recognized this use of force. Something that you would have imagined would have been a very basic measure to find out who the person was that used force against Ms. Wenzel. The only conclusion you can draw from this intentionally cursory review is that they don't really want to know who did it. It is a lot easier to defend against Ms. Wenzel when we don't know who the person is. They have access to the people, the resources, and the information. They didn't try to find out who did it because they don't want to know. But for our purposes, we don't need to know. We know it happened, and the person who did it was an RRT member of the Portland Police Bureau. You are going to be, or you were instructed, that the city is responsible for the actions of its employees, and that the defendant, the city, acts through its employees. Imagine a pedestrian, the same one we discussed earlier, but she gets hit by a UPS van and breaks her hip. She sues UPS, and their response is, well, you can't ID the driver, so it didn't really happen, or we aren't responsible. Not only is that just unfair, but it isn't the law you were instructed on. When you go back to the jury room to deliberate, you're going to have a verdict form, and in it will ask you questions about battery and assault and negligence. We don't have a copy of the verdict form yet, so I won't be able to go through it with you. But as you were instructed earlier, an assault is if an officer acted intending to either cause a harmful or offensive contact with the plaintiff, or to cause her apprehension that the defendant was going to cause an imminent harmful or offensive contact. Now, I'd submit to you that the plaintiff reasonably believed a harmful or offensive contact would occur. I think it's sort of a no-brainer that the elements of this claim have been satisfied. Similarly with battery, there is no genuine dispute that she was violently shoved from behind, which I submit that most people would regard as harmful or offensive, and that in any case Ms. Wenzel certainly did, and that it in fact caused her harm. and offensive contact. One of the issues that I think is going to come up when I'm done here is a challenge to whether or not we can show the intent of the officer involved. Because obviously we don't know his name and we don't know, they haven't come up here to testify what their intentions were. Now, if we look at the intent defined instruction that you were read earlier, it says intent means either the actor desired to cause the consequences of their actions, or the actor believed that the consequences were substantially certain to result from their actions. And the consequences in this instruction means the causing of the harmful and offensive contact, meaning hitting her with a baton and knocking her to the ground. Now, you heard testimony from Ms. Wenzel that when contact was made, that there was a shoving motion that actually was in part what launched her into the air. And that shows intent. You might run into somebody accidentally. You might trip over somebody accidentally, but you don't shove somebody accidentally. It was clear that the officer that did this acted with the intent to shove her and knew that it was substantially likely that when he did so, she would go to the ground, just like in Exhibit 10 and just like in Exhibit 11. So if you total up those requests for economic damages, you should come up with $15,606 in economic damages. That is her medical expenses for her arm, her psychiatric care, and her lost wages. And I submit to you that that's a reasonable sum. As you were told at the beginning of this trial, plaintiff is requesting $450,000 in non-economic damages. And I won't go over that instruction again in its entirety, but would note that it involves the pain, mental suffering, emotional distress, and humiliation that the plaintiff has sustained and probably will sustain in the future. Members of the jury, when you go back to deliberate, I want you to consider the woman in Exhibit 14. I want you to look at her and ask yourself, did she deserve to be violently shoved from behind, go to the ground, and break her arm? To be terrified and degraded and injured and humiliated? To be subjected to state violence with no recourse and with no accountability? I also want you to ask yourself, what would make this right? What would justice look like in the face of their impunity, their contempt for accountability? What would a just outcome be? The police do not police themselves. And in our system of laws, if you do not, no one will. We ask that you hold them accountable for their actions. Thank you.
Thank you, Mr. Burgess. And so, Mr. Manlove, oh, I'm sorry, Ms. Turco, we already went over that, my mistake. Do you have an estimate on your closing?
About 30 minutes, Your Honor.
Thank you.
Let me go on the other side of it, actually. Okay, thank you. Excuse me. No, it's fine. Yeah, that's fine. Thank you. Thank you. Good morning.
Good morning.
You may feel like you're being asked to judge the entire summer of 2020 and how the Portland police responded for that entire summer. You may feel like you're being asked to judge all the protesters, peaceful and violent, based on the actions of Ms. Wenzel. It's tempting to take this case and think we'll solve all of Portland's problems: houselessness, graffiti, shootings, you name it. But your job today is not so large. You are being asked to judge a very narrow question of what happened to Miss Wenzel and whether she has met her burden of proof. You have huge discretion in how you make that decision, but it sounds like such a daunting task. Where to begin? Well, there are 4 issues, and as the judge has instructed, there are the jury instructions and the evidence. Now, there's actually a jury instruction on evidence, which tells you that evidence can come in many forms. It can be testimony, it can be an exhibit, it can even be someone's opinion. The jury instructions give you huge latitude and discretion in how you look at the evidence. The instruction actually states that you may choose to believe or disbelieve the evidence, and that you, the jury, should give the evidence whatever weight you think it deserves. So the first issue that you'll be asked to address is assault and battery. And the primary jury instruction on that issue is called reasonable force. That instruction states that if an officer uses reasonable force, it is a complete defense to the claim of battery, but that an officer must be exercising a legitimate purpose. You have additional instructions that outline what types of purposes are legitimate. What authority does an officer have? And they include things that are perhaps common sense: the authority to direct traffic, the authority to disperse a crowd. And also, under the direction entitled pedestrian, it states that no person shall block a road. Another instruction that's relevant to the assault and battery is called good faith. And this instruction states that an officer is presumed to be acting in good faith when they're exercising a legitimate purpose. Lastly, you have the instruction of intent, and Mr. Burgess went over this. This instruction requires plaintiff to prove that the officer desired the consequences of their actions or believed with substantial certainty that those consequences would occur. This instruction requires you to look into the mind of the officer. We don't know who it was, how it happened, whether it was an officer or another protester. So it's difficult in this case for plaintiff to prove this element of intent. Now, let's look at what evidence we have on the issue of assault and battery. We have plaintiff's testimony. Plaintiff testified that she saw an officer that was 6 feet tall run at her, push her out of the way, and continue running. It's not clear that this officer was trying to hurt her, that he intended to hurt her. This officer was running up ahead to a crowd of 100 people. If this was at the same time that ball bearings and golf balls were being thrown by the crowd, then it would make sense for the officer to run up ahead and deal with that. There is no evidence that the officer intended to hurt Miss Wenzel. As for the second use of force, plaintiff testified that she fell into a protester who pushed her, and then she fell into an officer who was surprised, reacted, and hit her. Again, this was a reaction. There's no evidence of an intentional desire to harm Miss Wenzel. Plaintiff has shown the video of Officer Taylor, and there's the implication that he was the one that did this. But we know, we saw Officer Taylor. He's only 5'8". He doesn't carry a baton. We also heard from Officer Lehman. He does not carry a baton. Plaintiff has all the use of force reports from that evening, and there's no dispute that lots of force was used. This was a violent occasion. The city has not been shy about the facts. Yes, force was used. Yes, people were pushed. But as to this particular claim, plaintiff cannot prove the mindset of the officer. She cannot do that. Now, what other evidence do we have on the issue of assault and battery? We have the officer's testimony. One term that resonated throughout all the officers' testimony was the totality of the circumstances. What was the context? What was going on? We know there were projectiles, dumpster fires. There was a shield wall blockade in the street so that a TriMet bus was stopped. Mr. Manlove told you that he would prove certain things, and he did. He proved that plaintiff was wearing a helmet, wearing a respirator. Her husband was wearing a Kevlar vest, and they were standing behind the shield wall in the middle. This is the same location that the officers told us the agitators would stand so that they were shielded by the initial shield wall and they could throw things at the officers. Additional evidence we have on the assault and battery is the testimony of Corey Elia. He testified that the crowd was going to the police union or to the North Precinct. He said most people had helmets and gas masks. He said he tended to stand off to the side, not in the middle of the shield wall. He also saw dumpster fires and he saw the bus blocked by the protesters. There was likely someone that night who couldn't get to work because their bus was stalled out due to this event.
What's the objection?
There's no, she's speculating. There's no evidence
Sustained.
of that.
These are the details of the totality of the circumstances. Now, as Mr. Burgess already stated, we have the testimony of Dr. Yang. And yes, she did say that gravity could cause this type of fracture, that simply falling was sufficient. Now, Dr. Baskerville disagreed, said a height was required. He's not a surgeon. He seemed to think he had video of plaintiff being pushed. You'll receive the stipulations. And the last one states that Dr. Baskerville was mistaken. He never received any video of plaintiff being pushed. So the question is, what else was he mistaken about? We have Dr. Yang, the orthopedic surgeon, testifying gravity is sufficient. Now let's talk about what plaintiff didn't present. What evidence do we not have? We have no videos. We have no photographs, despite the fact that when you watch these videos, and as we've heard from journalists, there were numerous people filming and live streaming this event. As you watch the videos, you'll see cameras everywhere. But we have nothing to corroborate this event. Plaintiff claims this incident involved a baton, and there were lots of officers on the ground that night with a baton who pushed people, and she has all the reports that we've handed over. Plaintiff called none of those officers. None of them were subpoenaed to testify. Instead, they called the officers that didn't even use a baton. That doesn't add up. The second issue that you'll be asked to look at is causation. And as Mr. Burgess said, the primary instruction on this issue is called substantial factor, and he read it to you. It states that something is a cause if it is a substantial factor, and it defines that as an important factor. So we also have the testimony of Dr. Best, and you can see it here. She made the 2 columns. She talked about all of the various causes for Miss Wenzel's distress. The previous tear gas, that's not Portland police, by the way, that is not a part of this case. We don't know who did that. The arrest, her husband's second arrest at her home. She's there thinking she's safe. She described that as a very intrusive experience. That has nothing to do with Portland police. This was the feds, not us. Subsequently, the family, her extended family, they were doxxed, and that caused alienation from her family. Dr. Best testified about the various visits, and we have her records. She talked about them. We went through each one. Do they discuss the assault with Portland police? Do they discuss what happened with Portland police? Is there a diagnosis of PTSD? Her answer over and over, no, 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 no. We conceded this first visit, no diagnosis of PTSD, but she did mention the police. When you look at the exhibit with all the medical charges for the psychotherapy visits, this one's not included. Plaintiff's not asking for compensation for that visit. She's asking for all of these. Those aren't related. Now, I will say that when you look at causation, there's an instruction called expert witness. This instruction states that you are not bound by an expert's opinion, and this gives you, the jury, tremendous authority. You can give it the weight, if any, to which you think it is entitled. Now, additional evidence on this issue is going to be Exhibit 203. That's the initial chart note from OHSU on the early morning of August 15th when Miss Wenzel went to the ER. It states that she fell to the ground. There's no mention of the police. When you look at Exhibit 203, you'll also see that as to the left arm, it states it's a little bit sore, and the leg a little bit sore. This doesn't comport with what we've heard in trial. The third issue that you'll have to address is damages. And the primary instruction on this issue is called evaluating witness testimony. This instruction gives you guidance on how to evaluate witness testimony. It tells you that you can consider such things as the witness's manner while testifying, the witness's interest in the outcome of the case, and whether other evidence contradicted the witness's testimony. So let's take the first one, the witness's manner while testifying. What does that mean? Well, if you found that one of the witnesses was shifty, fidgety, seemed like they were lying, you're entitled to trust your gut and make your determination about whether or not you believe that witness. So the manner while testifying, perfectly legitimate reason to believe or disbelieve the testimony. The second one, the witness's interest in the outcome of the case. This instruction says that you can consider the fact that plaintiff has an interest, a monetary interest in this case. That may feel weird, inappropriate. You may feel like you're being judgy of plaintiff, but that's your job. Your job is to judge her. And the fact she has a monetary interest in this case is a perfectly valid reason to judge her testimony and evaluate it a certain way. Lastly, you can consider whether evidence contradicted testimony. This goes to the fact that plaintiff claimed, for instance, a left locked elbow, but the medical records don't mention that, and none of the medical experts who testified mention that. That means evidence contradicted the testimony, and so you can disbelieve the testimony as a result. The next instruction worth looking at is called physical facts. This is a very short instruction, it's just one sentence, and it states that your factual conclusions cannot be based on evidence that is contrary to established physical facts. This instruction basically means you have to listen to science. You can't conclude that Ms. Wenzel suffered a grade 4 fracture. We have no evidence in the record to establish that. The physical facts, the x-rays, show that it was a very minor grade 1 fracture that required virtually no treatment but some physical therapy. By the same token, you can consider the fact that there was the absence of a back injury. There was no back injury, no bruising, nothing. And this is despite her testimony. She was ran into and slammed in her back with a baton. Now, she was quick to say that she had a backpack on, but you can look at the videos, you can look at the pictures, you can judge for yourself whether that backpack was a sufficient size to insulate her. The next instruction on damages is called avoidable consequences. This instruction states that a person who has suffered damages has a duty to exercise reasonable care to avoid increasing that damage. There can be no recovery for increased damage caused by the failure to exercise such care. This instruction speaks to the fact that plaintiff's own behavior may have worsened her injuries. Did she go straight home after the first push, or did she continue walking around for over an hour? You can consider these facts, and you can consider whether certain damages, certain consequences could have been mitigated or avoided by her own behavior. As to evidence on the issue of damages, again, we have Dr. Yang's testimony of a grade 1 fracture. We have Exhibit 201, which is the off-work note that the provider gave on Ms. Wenzel's initial visit. On 8/15, they said she couldn't work that day or the 16th, but that she was able to return to work on the 17th. Now you can contrast Exhibit 201 with Exhibit 178, which is the email that she wrote to all of her coworkers stating that she broke both arms and her hands and she wouldn't be able to return to work. I would also encourage you to look at Exhibit 202. This exhibit is the diagram of the various physical therapy exercises that Ms. Wenzel was given. They show that she was encouraged to move her arms all around. You can contrast that with her husband's testimony that she was completely immobilized. He testified that he had to comb her hair, he had to bathe her, he had to open the fridge, and that she could not move both her arms for several weeks. Again, Exhibit 203, we already discussed that initial chart note that discusses some soreness in her arm and leg, but beyond that, there was no left locked elbow. The final issue that you'll have to look at is negligence. And the primary instructions on this issue are they both have negligent in the name. The first one's just entitled negligence. And then the second is called negligent conduct defined. You can read my writing. The first one, negligence, it states perhaps the obvious. It states that the mere fact an incident has happened is not enough for plaintiff to prove her case. And perhaps that goes without saying. But the fact plaintiff has been injured is not enough. She still has to meet her burden, provide evidence that the city caused this injury. Negligent conduct defined is a longer instruction, but I like to point it out because it includes a portion that cautions against something called hindsight bias. You've probably heard about that. It's an internal bias we all have that when we look at something in the past, we say, oh, I could have done that better. I could have not done that. That could have been prevented. It's really easy to say that now, looking back at an event. This instruction says that the hindsight approach is not appropriate and not what the law instructs. Specifically, the instruction says, do not judge a person's conduct in light of later events. Instead, consider what the person knew or should have known at the time. There are various pieces of evidence that go to the negligence. Firstly, the videos 109B and 143. These videos show the different things that we've already talked about, the dumpster fires, the TriMet bus, officers walking towards the shield wall. You'll see that people are not all pushed. There is a adjustment of force for the circumstances. You'll see an individual carrying a shield with a leaf blower, and he's gently nudged along. There's people holding shields in the street that are pushed. So there is a spectrum of force used in when we're talking about what is reasonable force. And when you look at the videos, you'll see some of those different applications of force. We also have the officer testimony. We heard from Officer Taylor, who said, it's a win if we don't have to leave the precinct. We heard from Detective Kammerer, who said, it's not helpful to push people down. The whole point is to push them forward and keep them moving in the dispersal. And we heard from Lieutenant Shaning, who said that officers are trained, when we're looking at training, they're trained to use reasonable force. In looking at the negligence claim, you'll also, as the judge mentioned, have an instruction on comparative negligence. And this instruction instructs you to ask the question of whether plaintiff's own behavior contributed to a negligence award. So if you find that money is awarded on the negligence claim, then the question is whether plaintiff's conduct contributed to that and whether she could have prevented what happened. Overall, there's a few pieces of evidence that I want to talk about that apply to all of the claims. The first is Exhibit 139, and it comes from video 122A. These pictures that we'll look at show that officers did push Ms. Wenzel. We know that at the shield wall, Ms. Wenzel encountered an officer. She was 10 feet behind the shield wall. Her husband says they were in that location for 15 minutes before the officers came across the intersection. They were in that spot for 15 minutes, having the opportunity to hear announcements. She says she heard no announcements. Then we see her here after the officers move across in close proximity with an officer in what appears to be physical contact, perhaps a push. The difference here from what we heard during her testimony, she remains standing. Now we can also look at Exhibit 155. This is from video 151A. Mr. Burgess referenced this video. This also shows a push sometime after the shield wall, and this corresponds with her testimony that it was a very large officer. You'll see that he pushes her lightly. Again, it doesn't help officers to disperse a crowd if people are falling. After this push, she's pushed again. Can we see Exhibit 162? So this series here, and you'll see you'll have the entire video to watch, corresponds to her testimony of 2 pushes. The difference here, obviously, is that she doesn't fall. This video and these photographs also show what the officers talked about, that there was plenty of room to move off the street onto the sidewalk, yet we see her remain in the street. Mr. Burgess has shown 2 other videos that show more violent pushes of other people by other officers. He wants to use those videos to sway emotion, to say that his client was pushed in the same way by those same officers. But that's not what the evidence show. These photographs show that she was pushed. She was pushed, and the force was reasonable, and she did not fall. More importantly, there was plenty of room to move off the road and onto the sidewalk. Now, overall, there's also 2 instructions that apply to all of the issues that we talked about. The first one is called witness false in part. This instruction states that if you find that a witness has lied in some part of his or her testimony, then you may distrust the rest of that witness's testimony. And what this brings to mind is Exhibit 178, the email that Ms. Wenzel sent all of her coworkers. You may think that that email is only relevant to the issue of lost wages, that should only be used when looking at the lost wages claim. This instruction tells you that whatever conclusions you draw from this email can be applied to the entire case. Likewise, when Mr. Manlove cross-examined Ms. Wenzel, he had to repeatedly remind her what she had said in her deposition in order for her to tell a consistent version of events. Another instruction that applies to all the issues is called preponderance of the evidence. This instruction states that if after weighing all of the evidence, if you cannot decide that something is more likely true than not true, you must conclude that the party did not prove it. This instruction speaks to the fact that this case is plaintiff's case, and it is plaintiff's burden to make her case. And if at the end of the day, you can't decide that it happened, if you can't decide that it was an officer, if you can't decide that it wasn't another protester, if you can't decide, that means your verdict is for the city because she hasn't proven her case. Now, with these instructions in mind and the various pieces of evidence, I'd like to briefly review the facts of the case. And in doing that, it's important to understand the neighborhood. We know that Peninsula Park features prominently in the neighborhood, pillar of this area. It's bordered on the north by Rosa Parks and on the south by Ainsworth. To the south of that is Killingsworth, and to the north is Lombard. To the west of the park is Albina. This area is adjacent to the historic Albina area. And then to the west of Albina is Mississippi. And then over here is the Interstate I-5. Now, with these coordinates in mind, we know that the protest begins at 9 a.m. and the crowd is at the park. We know that following that, the first shield wall is at approximately 9:30 at Ainsworth, close to the interstate. Then the crowd moves south, and from about 10 o'clock to 10:20, we have the second shield wall at Killingsworth in Mississippi. The officers break through that shield wall, disperse the crowd, and the crowd returns to the park at approximately 10:30. And that is then when, by Ms. Wenzel's testimony, the first and second uses of force occur. The first being approximately 10:30 to 10:35, and the second approximately 10:40 to 10:45. Now, what about the warnings? We've heard a lot about the sound truck. You can hear the sound truck in the background of all of the videos. We know that 3 announcements were given at the first shield wall. They all said, "Move off the roadway." The crowd does not move off the roadway. They move within the roadway. They set up a second shield wall. On their way south, the sound truck gives 3 more announcements. "Move off the roadway." The crowd does not move off the roadway. They set up the shield wall. At the shield wall, before the police go through, 3 more announcements. "This is an unlawful assembly. You must disperse." You'll have a stipulation, as the judge mentioned, with the full verbiage of all of these announcements. They're not as short as I'm making them. They go on, get out of the roadway multiple times. Before the police moved on the shield wall, plaintiff would have heard 9 different announcements. She said she heard none. That doesn't add up. After the protesters disperse from the second shield wall, we have 3 more announcements along Rosa Parks after the crowd leaves the park at approximately 10:42 to 10:45. And then we have 2 more announcements up on Lombard. All this time, the crowd is getting smaller. People are going home. While we're on Rosa Parks, that's when we have the ball bearings and the golf balls that Commander Dobson testified to. In total, 14 announcements were made in an hour and a half. And these are just the announcements from the sound truck. This doesn't include all of the warnings by individual officers, which you can also hear on the videos. Get out of the way, get out of the street. Plaintiff finally left the neighborhood after 2 hours. So plaintiff has said her memory of this event is spotty. So I think it's important to point out some of the ways that her memory of these events and her perception of what happened is inconsistent with the established facts. Plaintiff went to this protest as a medic, but she provided no medical services and wrote a number on her leg in case she would get arrested. This doesn't add up. Plaintiff claims she had a left locked elbow, but there is no evidence of any injury to her left arm. This doesn't add up. Plaintiff claims she was lifted up into the air by the baton push, but she suffered no back injury, and there was only a very minor grade 1 fracture. This doesn't add up either. Plaintiff says this was a family event, but she has a helmet and a respirator, and her husband is wearing a Kevlar vest. Plaintiff claims she got lost and couldn't get back to her car, but she was able to use the navigation on her phone to drop a GPS pin for her friend to come get her. Plaintiff claims she walked for an hour after the incident, unable to find her car, but we know the crowd ended up back at the park around the time she claims these incidents happened, and that's where she had parked her car. That doesn't add up. Plaintiff claims she was unable to work, cook, comb her hair, open the fridge, and she sent the email to her coworkers about having 2 broken arms. The medical evidence does not support this. Does it add up for you? No one is saying plaintiff is lying, but the question is whether she has a reliable memory of this event, whether her perceptions are credible. The city's position is that plaintiff does not remember this incident correctly. The city has been open and transparent about the force used that night. We've given over all of the use of force reports and had officers testify. The officers have been transparent that it's possible this happened. But looking at plaintiff's description and the medical records, it just doesn't add up. Plaintiff is not here for accountability. She's here for $500,000. This is not a case of a UPS driver, but of a chaotic mob where any of the other protesters could have caused this incident. The city asks that you find that the assault and battery did not happen. And if it did not happen the way plaintiff claims. Plaintiff should not be allowed to come into our neighborhood, cause chaos, and collect money for it. If you disagree and decide to award damages, the city's position is that the medical bills for the arm, approximately $6,000, are related, but that the psychotherapy, which never mentioned anything about the police, is not related. The city's position is that the wage loss is not related. In the end, a total award should not exceed $20,000. Thank you.
All right, jurors, what we're going to do now is take a lunch break since we're hitting the noon hour, and we'll come back. It would be great if you're back in the jury room at 1:30, and we'll return for Mr. Burgess's rebuttal argument. And then once we're through that, we will give the case to you to deliberate on. Hello. Did you look at the verdict?
Yeah, I just sent you.
Oh, okay. Does it look okay?
Yeah.
I just can't see the judge's face.
Sorry, I just.
No, you're fine.
Whatever.
I just.
That's where it would go.
I think they were, play this really, they would be left hanging.
Okay.
They didn't know the next thing
Okay.
to do.
Did you fix it?
Just
Well,
waiting
I
to
can
find
fix
out
it.
when Laura's coming back.
I just sent an email.
Okay.
But
Okay.
I can.
Okay, so team, here's what I want to tell you. I rewrote the verdict form. Anna looked at it. There were things that I messed up. We're fixing those. What we're going to do is email you the verdict form, and then it would be great if you're back here 1-ish for us to talk about the verdict form. And just generally the way I've structured it is they make a decision about whether or not unreasonable force is used, because if the force is reasonable, there can't be a finding on any of the other claims for the plaintiff. And then it goes into assault, battery, goes into negligence, and then the city's table is in there, which is kind of weird, and I feel like we need to figure out what, I read them the no duplicative damages instruction, but I feel like the easier thing to do is I think what the city is sort of implying they do, which is that they just write a verdict on each claim, and then we do the math at the end. And so I need to figure out what to tell them about that. And if we figure out what the verdict is, Ms. Turco, and you want to talk to them about the verdict form, you can come back, and then you'll both have the verdict form and can talk to the jury about it. So we'll get you that, and hopefully we can kind of work through it at 1, and nobody's too objecty about the way it's structured.
I'll try not to be too objective.
But if you are, we'll discuss it.
Okay, so with that being said, we're going to go ahead and shut down the stream for an hour. We'll bring it back up just like a few minutes before 1, and then figure out what's going on with the verdict form and get the closing rebuttal. And then I will start trying to work on figuring out how we'll know when the deliberations are done, because at that point we won't be having anything from the court until they start pulling everyone back in for the reading of the verdict. In the meantime, I definitely thank everyone for showing up that was here today. If you haven't already followed us or subscribed, feel free to do that. Share this out to other people that you think might be interested. This is something that is definitely going to set the tone for other excessive force lawsuits that are still winding their way through the court system. This just happens to be the first one that's actually made it to a trial. In the meantime, like I said, thanks for tuning in, and we'll see you after lunch.